Yes.
That may be permitted to draw your lordship's attention to item number 319 of the combined list. That's at page 318 of your lordship's list.
Combined list of
This is a hearing matter. I don't find that your lordship has fixed any date for taking up hearing matters. But then, my matter is really urgent because from 2024 it's awaiting a final adjudication. Any day, your lordship.
serving.
From 2024, it's awaiting your lordship's decision.
So what is the urgency?
Urgency is this, Lord. Then I'm to tell your lordship in short the fact. Lord, my client was dismissed from service. Now there's a provision for appeal. Appeal was filed, and the appeal was to be decided within a particular time frame. Now that was not decided, therefore I had to move this honorable court. When the matter came up for hearing, on the second day of hearing at the motion stage, now they appeared and they said that they have already decided the appeal. They submitted a piece of paper claiming that to be the appellate order. But then I said that that's not an appellate order. I wanted time to file a supplementary affidavit. The matter was fixed to next date. Now, from that date, the matter is not being heard. But if I lose here, I am to prefer another.
So it is basically a motion.
Yes, basically a motion. Therefore, I have. Therefore, I have prayed for an upgradation as motion.
The 2024 matters. I am trying to reach out everybody, Mr. Bandyopadhyay.
No, I'm just saying. I do not say like it is specific, but I find from your lordship's list that your lordship is gracious enough to fix certain matters by giving precedence and thereafter taking the list.
Those matters which are new filing and the matters where at the motion stage there is an urgency.
Yes.
But already those matters which are running in the combined monthly list, I am trying to already there today this matters will be taken up from item number. There are few matters, then 79.
But then this 319 will never reach.
Waiting for 2024. Allow me to progress. Let me see.
Kindly, may I come back after 10-15 days?
Yes, that
because
you always come, Mr. Banji. You can always come before this.
I am not claiming any privilege, but then your lordship will kindly consider
this. It is not a hearing matter.
No, it's not a hearing matter. That's why I have said I prayed for an upgradation as motion.
Let me see how far I can reach.
Yes, this is this. I'm giving this.
Let me see how far. Yes. Give the slip. Let me see how far I can.
But then I don't want to disturb you time and again, but I have to come back once again.
Yes, 2024 matter. Please wait. Just one week has passed. I am in this.
Yes, I am ready to wait till.
Let a chance be given so that I can reach you.
But I know your lordship. But I just tell I'm prepared to wait for the month of November. Yes. Let it at least be taken up in the first week.
Let me see. 2024 matter. Let me see.
I'm deeply obliged to you.
Yes. I need to mention one matter about a listed motion. Listed motion, my lord was earlier being my lord was directed to matter to appear on 3rd of November.
Yes.
10th of November.
Yes.
My lord, matter not appearing. That's why
I directed when it will appear.
My lord, not the coordinated bench. My lord directed to matter to appear on 4th of November
as
listed motion.
Listed motion. What is the urgency?
There is no urgency because it is a casual level matter.
When you have filed it?
I filed it in the month of May.
May. So let it appear in the combined monthly list of.
Not May. Well, thereafter.
Let it appear in the combined monthly list of December. Let me see. Yes.
Milord, subject to lordship's kind sanction, Milord. It's a new motion, Milord, filed in the month of September. Milord, it was taken up by the earlier bench, fixing the date on 4th. Identical issue, but the issue is before your lordship. We are the contractual laborer. Milord, the transfer order has been issued. That is under challenge, though there is a stay for a limited period. But Milord, it will be. Milord, the interim order will be closing next week. Milord, if your lordship allows.
When interim order is expiring?
Milord, next week. Milord, that is.
What is the date?
Milord, dates, I believe, Milord, I cannot mislead the court. Milord, 19th.
Then come back and mention
19th.
19th interim order will expire. So the direction for exchanging affidavit?
Nothing. It's a motion prima facie because before the vacation bench, the order was passed.
Yes.
For such reason, Milord, let it appear under the heading new motion, Milord, if your lordship allows. New motion. Any day.
Very well, a 19th new motion.
I'm great.
Malad, may I be permitted to mention these two matters, Your Lordship? Malad, this matter earlier bench was directed to the petitioner be present before the composite hospital, BSF Vidhan Nagar. They appeared and declared fit. Malad, for disposal, it's required 1 or 2 minutes time. Malad, otherwise, the petitioner will lose the seniority in the
Why?
examination, 2024 examination, Malad.
2024?
24 examination conducted by the SSC, that the medically unfit candidate.
When examination will be held?
Well, examination over panel published on 13 December 2020.
For the post of constable? Yes.
Well, this honorable court was pleased to direct the composite hospital BSF Vidhan Nagar to conduct a medical examination to these petitioners, and they have conducted and declared fit. Well, for disposal, it's the one post has been kept vacant. There is a interim order. Well, 2 matters.
So, have you filed any supplementary affidavit enclosing the medical report?
Well, there is a direction to appear after completion of these things, liberty to mention.
Liberty, show.
And the general, the order sheet is not annexed with.
Oh.
This.
Show me the order sheet.
Then may I come back?
Tomorrow. Mention it. Who is appearing for the respondents?
Respondent, I shall comment.
Serve notice, then mention.
Yes.
Mention on Wednesday. Yes.
My lord, this matter, relates to my arrear pension and my lord, leave encashment. And my lord, this matter appeared lastly on 24th October 2025. Coordinate bench directed that the matter to the next date be fixed on 19th of November 2025 as last chance. This is the order. Kindly have a look to this order. Let it appear on that day.
(2018) matter, wait for some time. Is it at the hearing stage? Must be.
Oh, my lord,
what was the order passed in 2018?
28, my lord, that was.
Is there any direction for filing affidavits?
Yes, my lord.
Yes. Monthly list of December under the heading hearing. Yes.
Lordship mentioning for this petition of 2024.
Yes, you mentioned on Friday. Yes.
Under the heading for orders. Petitioner joined in the BSF Lordship in the post of constable in the year 2023 Lordship, August 23. And Lordship on July 2024, he was terminated on the medical ground that he is suffering from hypertension Lordship. Challenging the same, he filed this writ petition, and while order dated February 2025, the Honorable Justice Arindam Mukherjee directed the SSKM hospital to constitute a medical board and to examine him. That examination is over, Lordship, and the medical reports is already submitted before the learned registry, Lordship. Previously, Lordship, matter was appeared, the direction was there to appear the matter and for under the heading for orders on August 2025, Lordship. Lordship.
August 2025.
25th August.
So it is at the motion stage.
Yes, Lordship.
So very well, motion, monthly list of December.
And the heading for orders, I have.
No, I do not generally place it unless until I hear it.
Annexed the order.
Motion for.
May I have similar to this item number 412 and 414 of the combined list. This is an assigned matter. I may recall before vacation, I mentioned this matter. She asked me to come after vacation. This is a matter where entire selection process was challenged. Question paper was leaked. I have sought for investigation and for cancellation of the selection process. Now, selection was stayed. Now, investigation is going on. Some charge sheet was filed. I have taken out now an application for 2 reasons. For fair investigation, this is one part, and second part is that some of the candidates are crossing the age. Unless the selection process is started de novo.
Crossing age means 60 years.
No. The eligibility to be eligible.
They have participated.
They have participated.
So 413, 414. Yes, it was mentioned a number of occasions. I am thinking because I am in this determination just 7 days back. This determination has been assigned to me. If possible, on Fridays after applications, these assigned matters are to be taken up.
Great. Should I?
So wait for some time.
I
Wait
need
for
not
some
hand over
time. If I cannot take up this matter, then you mention this matter after fortnight.
after fortnight.
Your Lordship, I am also mentioning the same.
Yes,
same
yes.
assigned matter, Your Lordship. The internal
Assigned and assigned matters, I am contemplating to fix up on Friday after applications. Let me see.
maybe fixed up, Your Lordship. We had mentioned it on.
Yes, 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 yes.
Today was the hearing date in the court of Madam Anuna Bandyopadhyay, but it has not come. That's why
Who is? How do you know Justice Bandyopadhyay?
it was under the hearing stage.
What is this, Madam Ananya Bandyopadhyay?
No,
How long you are practicing?
no.
Are you aware of that? How to mention the matter before the High Court? How long you are practicing? Is it the way to name a judge?
No, it is my mistake. I apologize.
Yes.
For hearing, I have mentioned for inclusion.
For hearing inclusion, wait for some time. Hearing I am not including now. Yes.
It's a new motion matter, my lord. My lord, previously writ petition was filed, direction was passed by
Motion.
motion.
Motion of which year?
My lord, this year.
This year. Monthly list of October, December under the heading motion. Yes.
I'm getting.
Your Lordship, this is a motion under service 2025, my lord. The petitioners are the hostel staff, my lord.
Yes.
Petitioners are the hostel staff, but the remuneration is very poor, my lord. They claim for monthly remuneration passed by
Hearing or
notification.
motion
Motion stage, my lord.
of which year?
2025.
2025 motion. It is not appearing.
No, my lord. Previously, it was appearing before the Honorable Justice Aniruddha Roy. Aniruddha Roy passed an order on the same matter, but the other matters are not coming. After
In
change
the
of
self
determination.
similar matter, what was the order passed?
Uh,
Come ready. Yes, yes, yes. Motion. Month list of December. Yes. Application December list. How many matters are there? When you have filed it? When you have filed it?
For my lord, it was 2021 on the last day when before Justice Aniruddha Roy. Honorable Justice Aniruddha-
Month list of December. Yes.
My lord,
Wait for some time. Yes.
my lord, if I may be permitted to mention,
May follow the system.
My lord,
You are
the-
junior member of the bar. This is not the way to jump over others. Yes. Yes, yes, yes.
My petitioner is retired due to correction of date of birth. Now there was a wrong date of birth. Now he is not
See, hearing or motion
motion.
of which year?
2025, my lord.
2020 is not appearing in the list. Month list of December.
My
Yes.
lord, may I be permitted to mention? I have mentioned also on Thursday. My lord has said to mention me on Monday. This
Yes.
is matter relating to the CRPF Jawan. The DME will take on 12th. My lord, already this matter was earlier mentioned. Was supposed to fix on 4th by my lord Justice Honorable.
Supposed to fix on 4th means?
Supposed to be on list on 4th. My lord Justice Aniruddha Roy was heard this. I had mentioned before.
How
In fact,
many matters are there?
only one matter, my lord. Only one
What is
matter.
the urgency? 12 medical test will
Well, medical
start.
test,
And it will continue for some time.
But my lord, the matter is not in the list. Kindly take it up urgently. I am supposedly
When
fairly
the last order was passed by the coordinate bench?
in the vacation, my lord.
During vacation.
During vacation also.
What
this
was the order passed?
order passed that 169.5 will be considered as 170. I am fairly squared under coming under
No,
this.
in your matter, what was the order
No
passed?
order was passed, my lord. New motion, fresh.
New motion, no order was
No,
passed. When
no.
you have filed it?
I'm filed on September, my lord.
In the month of September.
September.
So, who is appearing for the other side? Do you know?
I will serve the copy on to
So, how do you come to know that the 12th is the date for
that
medical
is
test?
there in website they are showing. in the SSC website, they are giving the tentative dates from which it will start, and from that day.
From which date it will start, it is there, but in the
Also, it will
website, how long it will continue, it is not there.
Up to December, my lord.
9 December.
I said, my lord. And last occasion when I mentioned.
Very well.
I said,
Combined monthly list of December. Let it come, then I will see.
My lord, it will be December,
September monthly filing. Yes, wait.
My lord, if I may be permitted to
If
mention a matter.
is not let it appear in the combined monthly list. Combined
My
monthly
lord,
list
it was
is
fixed on
coming
4th,
on
my lord.
1st December. Then you mention. Yes.
My lord, it was fixed on 4th.
Maybe,
By my lord,
yes.
My lords, mentioning a matter for upgradation. This is WPA 26270 of 2024. My lord, the petitioner is a
Hearing or
constable. Motion, my lord.
Of which
Motion.
year?
2024, my lord.
It has never been heard.
It has not been heard, my lord. I'm afraid the petitioner is a sole owner of the family constable.
Monthly list of December. Yes.
My lord, for upgradation.
No,
my lord.
sorry. Yes.
May I be permitted to mention matter of 2024 of motion?
Never been heard.
It has been heard by Honorable Justice Arindam Mukherjee.
What was the order passed?
In one matter, Justice Mukherjee has directed to exchange the affidavit.
So how it is motion?
Your Lordship, since then the matter has not.
How it is? You are mentioning it as motion. Is it the system?
Let it.
Whether this matter is to be treated as motion?
There were 70 petitions.
Sorry. Yes.
Your Lordship,
Sorry. Whatever may be, there may be 73,000 candidates. Yes. Don't try to outwit this court. Yes. Court will remember you are junior member of the bar, and court, when you are court is specifically asking you, you are saying it is motion. This is pity. Yes. Yes, Mr. Kundu. What examination? Medical test. When it has started? When it will start? When medical examination will start?
12th or 12th November it will start. It will continue till 9th November, December. And what happened is it matters to appear. But the respondent authority did not appear. That's why it makes after vacation. Any date?
How many matters? November 24th. ও যেটা করলো ওটাও দিয়ে দেবে এই একই ম্যাটার। Yes. Contempt arising out of the order passed by this court. Monthly list of December.
May I be permitted to mention it's a 2025 matter, new motion. It has not been taken up for
Monthly list of December.
My lord, there is an urgency. The petitioners are all retired employees.
When you have filed it?
Lordship, January 2025.
When you have filed it?
9th January 2025.
Please hand over the slip. Yes. Arising out of the order passed by this court. Old contempt. Of which year?
The year 2014, my lord.
2014. এই ওটা নিয়ে নেবে তো 11 থেকে 18 ডিটারমিনেশন আছে contempt. Yes. Hearing I am not taking at present. Wait for some time. Mojumdar, wait for some time. Let me see. Then hearing or motion? Application. When you have filed it? Group 6. Hand over the slip. Yes.
Roy, the motion law. Before changing of determinants. Therefore, we going before this court as a mistake also. It was released from his lordship's court on the last week lordship and made this before this lordship.
Motion. Hand over the slip. Hand over the slip. No, hand over the slip. Monthly list of December. Maybe, yes.
New motion matter for inclusion of the new.
Yes, new motion. Monthly list of December. Yes.
Madam, may I leave to mention this is order dated 19/8/2025 passed by the Honorable Justice Aniruddha Roy. The matter shall be fixed on 6th November 2025 for heading of the order. For order, my lord. Because the urgency is, my lord, this is a CWC committee. There is a chairman.
Is it hearing or motion?
Madam, it is order, my lord.
Is it hearing or motion stage?
Hearing stage, my lord.
What was there any direction for filing affidavits?
Yes, it's already directed and it is, well, it is annexing the.
Wait, you have to wait for some time. I'm not taking up hearing matter at this stage.
Yes.
Yes.
Lordship, mentioning this matter, praying for correction passed by correction of order, Lordship, passed by your Lordship, pursuant to earlier determination, Lordship. What happened?
When this order was passed?
It was passed on 28th of August 2025.
So why you are mentioning September, October, November?
Lordship, what happened in this matter? Lordship directed the district inspector of schools to take decision about the fate of the panel submitted by the school, Lordship. But the district inspector, we have communicated this order to district inspector of school, additionally to additional district inspector of schools. But the district inspector of schools is declining to take any action since no representation was submitted before him earlier. Lordship, that we have repeatedly.
Then you have to file an application. Correction is not possible. Yes.
Application which was appearing before the Honorable Justice. Thereafter, there is a change.
Application.
No, the new motion. The difficulty, madam, the person has been removed from the service having the civil consequences, madam, on the ground of.
Removed from service. When removed?
Madam, it is removed 2 to 3 months back. There was one petition which was challenged for the joining.
Hand over the slip. Hand over the slip. Hand over the slip. Let me see.
Honorable Justice Honorable Mukherjee on 2nd December 2024. Now, thereby giving direction.
2022.
2024, madam. But thereby giving directions to the respondent authorities to file.
Hearing or motion?
Hearing.
Wait for some time. I have not allowed anybody's mentioning regarding hearing. Wait for some time. That means you mentioned last week of this month, just before publication. Let me see how far I can reach. Then I will try to take up hearing matters. Yes.
For inclusion of contempt application.
Month list of December.
Your Lordship, this is the matter.
Old contempt or contempt arising out of my order? Of which year?
70.
Old contempt. Yes.
This is a matter of 2024. Now, this matter was already been before Honorable Justice Aniruddha Roy, and he had fixed this matter on the 19/11/2025. And there was a direction for affidavit in reply, which has affidavit in reply and this.
So the hearing matter, direction for affidavit. I am not including any hearing matter. Let me see if I can make some progress in the list. Then I will accommodate a hearing matter. Yes.
Compassionate appointment.
Motion or hearing? Of which year? 2025. Hand over the slip. Of which year? Hand over the slip. You have mentioned already. Yes.
May I permit to mention, Your Lordship? Lordship, this I am mentioning for upgradation, Your Lordship. The urgency is, Your Lordship, the date of examination.
Hearing or motion?
It's a hearing, Your Lordship.
Hearing.
Hearing. But extreme urgency, the date is the 29th of November, Your Lordship.
Sorry.
The Lordship pleading have completed, Your Lordship. Kindly fix the date
No,
before
no,
29th.
no, sorry. Yes.
If we not getting chance, Your Lordship,
No,
will
sorry.
detract from the
Direction for affidavit. Sorry. Yes.
My Lord, may I permit to mention a matter for non-prosecution?
Non-prosecution. Matter of which year?
Lord, 2025. 2025.
Thursday to be mentioned. Sir, notice of another side. Yes.
Granted, Your Lordship's kind leave to mention the matter. My Lord, this matter was appearing in the daily cause list prior to the change of determination. Lordship, thereafter the matter is not appearing. I'm mentioning this matter for inclusion in the list.
Motion or hearing?
Motion, Lordship.
Motion.
Motion.
When it was when it last appeared?
Lordship, on 31st of October.
31st October.
October, Lordship.
So after change of determination, it is not appearing in the list. So let it appear in the monthly combined list of December.
Grateful, Lordship.
I am mentioning my matter. This is a listed motion, my lord. Petitioner is a labor of railway.
Is it appearing in the list?
It appeared in the list of October, a daily list.
Matter was heard.
No, my lord.
Never heard. So it is appearing in the list. It is not there in the list.
No, my lord. It is not in the list.
2025 motion. So let it appear in the monthly combined list. December. Yes.
Same issues. But the only
Motion.
Motion, my lord, 31st October appeared, but it was taken up twice. But the respondent.
Hand over the sleeve. Hand over the sleeve.
Just, I will take. Issue is that recovery has been ordered from the pay of the High Court staffs. The only urgency is that the recovery should be stayed till the matter is heard of. your lordship kindly grants me, I can come back with an application.
Recovery order passed by whom?
Recovery order passed by the deputy registrar.
Yes, that you have challenged.
That we have challenged, and accordingly, because there is a high discrepancy in the whole pay scale structure. That is the major challenge, which is actually not as per the rule under Article 229(2). That is the main challenge, your lordship.
Very well, their court will consider. So you have filed a writ petition. Well, hand over the slave. Yes. No upgradation. Yes. No, it will appear in the monthly combined list. If the list is if the list is exhausted, then mention this matter.
Lord, may I mention?
Then I will try to take up.
Lord, new motion. May I pray for inclusion of new motion?
New motion, 2025 motion.
One is 2025 and one is 23. 23 in view of the fact that the matter had gone to division bench. Honorable division bench has passed that. Let it go to single bench.
Very monthly combined list of December.
Much obliged, Your
Lordship, may I have your kind leave to mention a hearing matter of 2019 for inclusion in the list?
No, hearing matter, we have to wait for some time. Yes. Please make an application. I have heard you. I am saying that you have to file an application for modification, or otherwise in this fashion it cannot be. Yes. Call the list. Yes.
Sir,
Yes.
in person আমার ফেস করছি
Yes.
তো আমার স্যার ইনক্লুশনের জন্য আমি জমা দিচ্ছি স্যার মেনশনিং
Inclusion?
হ্যাঁ ফর
এটা কি হিয়ারিং স্টেজে আছে না মোশন স্টেজে আছে? আপনার লাস্ট কবে হিয়ারিং হয়েছিল?
লাস্ট স্যার গেল বছরের হয়েছিল।
গেল বছর মানে 2024?
না স্যার 2025-এর হচ্ছে পুজোর ছুটির আগে, মানে 11 নভেম্বরের লাস্ট ডেট ছিল।
2025-এর পুজোর ছুটির আগে হিয়ারিং হয়েছিল।
হ্যাঁ হ্যাঁ।
কি অর্ডার হয়েছিল?
অর্ডার স্যার
অর্ডারের কপি আপনার কাছে আছে?
হ্যাঁ স্যার সবই
দেখান।
আছে। অর্ডার কপি তো এখানে আমি স্যার নিয়ে আসবো আমি কপিটা। স্যার আমি যে ক্যান ফাইল করেছিলাম তার সঙ্গে এখানে সেই অর্ডারটা আসছে।
আপনার তো রিট পিটিশনটা ডিসমিস হয়ে গেছে,
হ্যাঁ
কেউ অ্যাপিয়ার করেনি বলে। তাহলে এখন আমি কি করে মামলা লিস্টে তুলবো? মামলা তো ডিসমিস হয়ে গেছে, কেউ অ্যাপিয়ার করেনি, তখন মামলা
ফাইলিং করেছি, মানে সেই প্রসেস হয়ে গিয়েছে। হয়ে তারপরে স্যার আমার মানে আমার মোবাইলে যে নাম্বার অ্যাড, মানে আমার
আপনাকে শুনুন, একটা ক্যান ফাইল করতে হবে।
ক্যান ফাইল করেছি স্যার,
করে সেই ফাইলের নাম্বার আপনাকে দিতে হবে।
হ্যাঁ ক্যান ফাইলিং
দিলে এটা অ্যাপ্লিকেশন হেডিং এ, তাহলে আমি তখন ডিসেম্বরের লিস্টে দিতে পারবো।
হ্যাঁ স্যার, মানে এটা তো সবই আমি
ক্যান নাম্বারটা আপনি তাহলে আপনারা আমার অফিসারকে দিন। ইয়েস, কল দ্য লিস্ট।
এই যে স্যার
Yes.
I am petitioner in person. So my case is running to
number 1, 2, 3.
Honorable Judge Aniruddha Roy. So I am my one petitioner already died. So my financial lack of financial crisis, I am decided to own petitioner argument. To so kindly mention my.
এটা কি আপনার মামলা কি লিস্টে আছে?
হ্যাঁ লিস্টিং এ মানে আগামী 12 তারিখ নভেম্বরে
লাস্ট কি অর্ডার হয়েছিল দেখান। তো অনেকগুলো রিট পিটিশন।
হ্যাঁ 5 কেস অলরেডি মানে ট্র্যাক করে দিয়েছিল। তো ওখানে আমার থার্ড অদ্বৈত দিন তো ফর অর্ডার 12 নভেম্বর, তো ডেট অফ ফিক্সড ছিল।
না, এক্ষুনি এই মামলাটা নেওয়া যাবে না, এটা হিয়ারিং স্টেজে আছেন। উকিল বাবুরাও অনেক মামলা মেনশন করেছেন সিমিলার ম্যাটার হিয়ারিং এ। আমি এখন নিতে পারিনি, কারণ মোশনগুলো আমি কিছুটা শোনার না শুনে আমি এই ম্যাটার এখন নিতে পারবো। এখন আপনাকে আবার কিছুদিন বাদে মেনশন করতে হবে। Please don't mention any matter. Please call the list.
Item number 1 to 3.
Extend the interim order.
Yes.
Extend the interim order. My lord, is not the.
Oh, matter has come for extension, right? When the interim order was passed?
Affidavit
Tell
is
me
already completed.
Tell me the date of passing first interim order. Justice Chakraborty, as his lordship did, then was passed interim order.
I have all the copies. Total copies are yours.
When 15th May 2018, first in, oh, we have copy. 31st January 2018. Order a copy করি 29350 এই 29350টা দাও তো ওটার কপি তো খুঁজে পাচ্ছি না 31st of January 2018 31st of July January দেখছি দেখি চার 2008 কিন্তু different dates আছে টাঙ্গাইলে থাকতে পারো Where is annexure P7? Circular dated 6 January 2017. Show me circular dated 6 January 2017. You are enjoying interim order from 2018. Already 7 years have passed. Show me the circular. Yes, I am on writ petition number 29350.
The first interim order was published.
Wait, Mr. Raichowdhury.
17.
Yes, that I've seen. Who is appearing for LIC? You are for the Union of India?
Yes.
Yes.
I'm not the answering respondent. They are the main.
Yes. Yes, where is the circular? And there is no exchange of affidavits till date. Show me the circular. I generally do not pass mechanical extension of interim order. Yes, you are not prepared, it appears. You are not in a position to show me the crux of the issue. You are taking so. Please show me the circular.
এটা না 2935
Kindly see page 73, annexure P2. 29350.
No, this is annexure P7.
Pilot is asking for June 2
No, which has been stayed. That is annexure
Yes.
P7. Where is annexure P7?
126
126. That is the 2017.
তারপরে কত আছে 12 তারিখে চেক জানো তারপরে কত আছে
Yes, where is the wrong in this order? Because nothing was heard on merit. Only Mr. Rai Chaudhuri prayed for time. That is why court granted interim order.
I had been praying.
Yes, where is the wrong in this refixation order?
Which one?
Where is the wrong in this refixation order?
Then I have to explain it right from the
Come back when we want to explain it.
now itself.
When you want to explain it.
Now itself. Now I'm here itself.
Yes.
Now itself.
Now itself. Yes.
The basic fact is that the petitioners are all legal exceptions.
Yes.
They have completed 20 years term in the defense. Thereafter, as per the benevolent orders of the government to protect their future, government has created reservations for different sectors, government sectors. In accordance with the quota fixed for them, these people they joined LIC somewhere in 2008 and 2009. Immediately after joining,
Yes. Go carry on.
immediately after joining, their pay was fixed as per Annexure P2 month. Annexure P2 is in pay 73 month. Annexure P2, actually that is the only circular on the basis of which that original fixation for them was given.
Now the differentiation has been made based on the educational qualification.
No, not that one.
Yes, that is the part of page 126 onwards.
No.
Ex-servicemen joining in class 3 and 4, and then next page it says that ex-servicemen joining in classes 3 and 4, and ultimately it is stated that for graduate ex-servicemen there will be further monetary benefits.
No, that is not the issue. Let me explain it. It's a very serious issue, and in all over India, in all the high courts all over India, stay is going on. Injunction interim order is going on. One case is that Kerala case is before the Supreme Court.
Show me that order.
Of different high courts of all over India. On the same subject.
Show me which order. Don't give me this bunch, because court is considering extension of interim order. Be precise.
Here the first order is in the High Court at Patna. Then thereafter there will be Mumbai, Kerala, serially.
What is the best order you want to rely upon in order to assert that this is a case where this extension should be granted?
যে কোনো একটা হাইকোর্টের বেস্ট অর্ডার যেটা সেটা দেখানো হচ্ছে।
Which squarely covers your case. Come ready tomorrow, let it retain its position. Don't waste court's time. So that's why interim order is too extended. It's a huge case.
On merit, it is against the Supreme Court order also. I have another Supreme Court order also in this case.
So that is not applicable.
It is totally against Rafiq Mas's case also, that line also.
Whether the petitioners are all retired ex-servicemen.
Few have retired and most of them are still.
Now retired from LIC.
Yes, and most of them are still on the verge of return. They are in the service.
Your pay was fixed in terms of Annexure P2.
Yes, madam. That is the main issue. And after 8-9 years in one fine morning, they
Issued this refixation order.
without giving any explanation there. See that Annexure P2 is so exhaustive. They have explained how it is.
And after that, 3-4 another notification issued. The last one is in 2017. In 2017, the last line, Malak, kindly see, the recoveries, if any, are to be effected immediately. What we are doing, Malak, after the refixation, we paid somebody extra. Now we are recovering.
Now, as he is relying upon Rafiq Mashi, paragraph 18 of Rafiq Mashi says no recovery.
He is not relied at
After
all.
retirement or within the span of 2 years preceding retirement.
Well, it is, he relied not at all. This judgment is showing the first time before this court.
No, I am telling you, in Rafiq Mashi, there is a protection.
Yes, but what I am trying to say, in the notification itself says 2017, which is in page 126. Their notification says
just a minute, Mr. Rai. Just a minute. Wait. But do you have the copy of this order? This order which you are relying upon, the order of the Kerala High Court Division Bench?
Yes, it is there at the end portion, division bench order.
Yes. Do you have the copy of this order?
So that's all I have.
Yes. Please read paragraph 11. With regard to recovery, perhaps it said that thus we set aside the judgment of the judgment to the extent of denying the relief with regard to the order upholding pay fixation. The same is set aside. Judgment of the single bench was set aside. Writ appeal stands allowed. The rest of the order protecting the interest of the appellant petitioner for recovery of excess pay is upheld.
This matter has been taken on exultate by Life Insurance Corporation of India before the Honorable Supreme Court. I am talking as on date.
Yes.
I have the Supreme Court order also. It is right now pending before the Supreme Court, Honorable Supreme Court. So naturally, it is still on the process of court.
Now, do you have the copy of the order of the Honorable Supreme Court, whereby protection has been given to the similarly circumstanced petitioners, other candidates? The SLP which was preferred against the order dated judgment dated 22nd February 2024 of the Division Bench of Kerala High Court. What was the order passed by the Honorable Supreme Court?
Order recently on contempt petition also filed before the.
No, show me the order by which the protection was given to the similarly circumstanced ex-servicemen who were working in LIC.
Supreme Court has right now, my lord, admitted the SLP one, admitted the SLP, and didn't grant any stay for recovery to the LIC. So what has happened on the basis?
So if recovery was not stayed, then so far.
No. Supreme Court gave the verdict in favor of right now. That first day order was in favor.
Where is that order?
That order soft copy I have, but on the basis of that already.
No, contempt will come later. Where is the order against the order of the Honorable Division Bench of the Kerala High Court?
There on the soft copy in the mobile.
You should come prepared. You should come prepared.
It's there, but I'll have to take it out and give you. In the division bench order matter that SLP is mentioned, it is suited hearing.
Mr. Rai Chaudhary, what is your instruction regarding the present situation?
My instruction is, my lord, according to the last notification, which is in page 126. The notification itself gives us liberty that if there is anything paid extra to them by mistake or by calculation wrong, my lord, that was in the, kindly see, then it was said in page 128, since these guidelines are applicable for ex-servicemen re-employed on or after such and such date, all officers are advised to refix the pay of ex-servicemen Then, mother, last line. The recoveries, if any, are to be effected immediately.
But one thing is, which was considered by the Kerala High Court Division Bench, that a circular dated 6 January 2017, which is subject matter of challenge in this writ petition, was passed on the basis of the applicability of the amendment in the rules 1985. Now, however, the said rules became effective only from 1st of August 2012. 85 rules became effective in August 2012, whereas the appellant petitioner was in service of LIC with effect from 1st June 2009. So, how this rule of 1985, which came into being on and from 1st of August 2012, come in favor of come in aid of the aid of LIC.
All these petitioners, my lord, was ex-servicemen.
Yes,
including my learned friend. What happens, my lord? They joined after 2009 in LIC, after working in as army. My lord, in LIC, the policy was those who will join from army, they will not be paid less than what the normal category of employees are getting at the time of joining. So they are always getting normal category. If 10 rupees, they are getting 12 rupees because they are ex-servicemen. They are the priority. Accordingly, 3 separate notifications then came in 2010, 12, 14 and 17. But the last one is 2017. While refixation of the last salary, these ex-servicemen somewhere reduced because of 2 reasons. Because of the basic pay and other categories of payment. Because of that amount of payment, Malad, we have prepared a chart also of 3 different categories of, because here the one Subhash Banerjee, what Malad is handling, one is Rajiv Dotto and one is Arun Noshkar. We have categorized how much they are reducing. Accordingly, per month they are getting what they are getting, less than that is approximately 4,000 something else. So 4,000 something else into 12 months. So that amount we are reducing on the basis of this particular last
2017 circular.
Yes. Then they challenged before this court, and the first day on 2017, 1912, when the matter was heard by Honorable Justice
Chakraborty
Banerjee at that point of time, he granted interim order on the ground. I have no instruction on the.
Yes, that is the purport
That
of the
is
order.
the first one. Malad, nothing was heard in the meantime. That was going on constantly. In the meantime, affidavit was already completed. We said that the judgment of the Supreme Court in Rafiq, that was not applicable to us.
But he is submitting that on similar issue in other high courts matters were issues. This issue was considered. Orders were passed against one of such orders. SLP was preferred before the Honorable Supreme Court, and Honorable Supreme Court passed an order, and the Supreme Court is in scene of the matter.
What happens, Malad, in that in that matter which Supreme Court is hearing, no order, final order was passed.
Maybe, but the issue is pending before the Supreme Court.
Maybe.
So, do you have any instruction with regard to the order passed by the Honorable
this
Supreme Court?
particular matter is concerned, Malad, this is for the first time he's showing this judgment. Even the Kerala High Court judgment he's not showing as on today. He's just verbally speaking before this court. Malad, what I'm submitting in the affidavit which they have filed in the reply, nothing was mentioned about this. Nothing.
No, but what is your instruction?
My instruction
because everywhere in all states, LIC is the main contesting respondent.
Yes. Malad, in that case, my instruction is what we have reduced is perfectly on the basis of this last.
So whether in other states where the issues are pending before the Honorable Supreme Court, this circular dated 6 January 2017 could be given effect to?
No, Malad. What my instruction is that we are reducing on the basis of this notification.
Yes, but whether the reduction could be made possible?
Yes, we are saying yes, reduction is possible because of the
stated in your affidavit in opposition.
Yes, we state it.
In spite of the issue being issue is pending before the Honorable Supreme Court.
So that matter, prior to that, the affidavit was filed.
Very well, obtain instructions. Let me extend the interim order at least for a limited period. And in the meantime, I am placing this matter in the monthly combined list of December under the heading hearing, because matter requires consideration.
In the meantime, Malad, kindly direct my learned friend to give all the orders in a compiled form in a supplementary affidavit so that we can take.
No, you obtain your instruction.
No, I will.
Already
of course.
affidavits are completed, so.
No, these orders was passed after that. Affidavit was prior to that.
Matter is heard to certain extent in presence of the learned advocates representing the parties. Stop. Learned advocate representing the petitioners submits that similarly circumstanced ex-servicemen working in Life Insurance Corporation of India within bracket for short LIC close bracket are getting the pay based on fixation made at the time of joining in LIC and impugned circular dated 6 January 2017 till date has not been given effect. Stop. The issue is issue is pending before the Honorable Supreme Court. Are you in a position to indicate the appeal number?
Yes, it is quoted in the division bench order. Just now, division bench order, Kerala division bench order. Just now, it is quoted that it's the number.
Stop. Next paragraph. Stop the learned advocate representing the petitioners also submits that that similar issue is pending before the Honorable Supreme Court for consideration. Is pending before the Honorable Supreme Court. Stop. However, order of the Honorable Supreme Court is not placed today, and accommodation is prayed for to bring it to produce it on the next date. Next paragraph. Learned advocates representing the parties have also submitted that affidavits. Representative parties have also submitted that pleadings are complete. Next paragraph. List the matter under the head. List the matters under the heading. Or list the matter under the heading. Hearing in the monthly combined list of December 2025. Next paragraph. Interim order passed earlier is extended till 24 December 2025 or until further order, whichever is earlier. Three separate matters, three separate orders are being passed.
The issues are same.
But previously I find that the
yes, three separate orders. Last order was passed by
একটাতে করবে এইটা দেখে নিও one common order in three matters.
Connected. Last 1 year that is going. Yeah, kindly take back those orders, madam.
Bring the relevant, bring the orders passed by the Honorable Supreme Court on similar issue where appeal was preferred from the orders passed by the high courts of different states.
Yes, madam.
Take it back. এটা দিয়ে দেবেন next
Item number 4.
I appear for the writ petition.
I appear for the respondent corporation.
I understand that in an identical matter, on 6th, Lordship has already passed an order. But even then, if I can just give the bird's eye view of the matter. I was appointed in November 13 as a development officer of the LICI. June 15, I was confirmed. So last 12 years as a permanent employee, I am serving. Now LIC, they changed their rule. They wanted to have a rule even for a permanent.
Who is appearing for LIC?
I appear for the LIC.
Even for a permanent employee, 3 months notice or salary can be terminated as far as we are concerned, development officer. Now, we do not appoint the agents. We do not have the disciplinary power over the agents. We also cannot do any business. Now, all over India, including our Honorable High Court, we challenged. Now, there is a show cause. Now, at least the 10 separate honorable judges of our court, the main order was
So
that
my
the-
issue is pending before the Supreme Court
yes,
also.
yes. A lordship has. So I don't let them continue. No final order be passed.
Yes, yes.
Because
That was the order I have
yes,
passed
yes.
6 November. As Mr. Dhar, you have.
But I have the number, but that is yet to.
No, I have the copy of the order is with
is
me.
there.
Because your junior indicated that
Yes.
there are several other matters
Several.
which are
Correct,
coming on
correct,
Monday.
correct. Because my lord, it has a larger implications. Like for 13 years, someone is serving, suddenly you get a notice and say, right or wrong, that's a different thing. That kind of protection. So I'm seeking the same.
Only, my lord, there would be a small exception to this matter if my lord takes up the impugn notice once. That comes up at page 49.
Yes.
If may I just, my lord, in a nutshell, what happens? These are development officers.
Where is the scope now?
No, my lord.
Similar issue is pending before
So
the
the
Supreme Court.
difficulty is why this is an exceptional case. My lord kindly takes up the second last paragraph.
Of page
49.
Sorry?
49. You are hereby given an opportunity to confirm through a representation in writing the discrepancies, if any, in the figures relating to your performance.
I've given
There
it.
is no decision making in the impugned notice, my lord. If no reply is received within stipulated time, further action will be taken.
No, I have given a reply. And
This is a writ petition based on assumption.
kindly see paragraph C after the table. It is for termination.
This is not a show cause to termination. And if my lord takes his reply at
That is in terms of the rules of 2016.
that is in terms of the rules,
You
asking
have
him
invoked that rules.
asking him to confirm the discrepancies. There is no decision making, my lord.
Oh, sorry.
And my
You continue, but no final order is to be passed.
but my lord kindly records my objection to that.
If no reply is received within the stipulated
Yes.
period, further action will be taken in accordance with the aforesaid provisions of Life Insurance Corporation of India, so and so rules of 2000 and amended
Yes.
Life Insurance Corporation of India Development Officers Revision Rules Amendment Rules 2016.
Yes, and that further action, my lord, would be
Nothing
an
is
show
required
cause
in
to
this. I have
termination.
considered it. I have passed order. Sorry. Yes.
And my lord, one more thing, at page 51, he himself admits
Affidavit is filed.
that this is not a show cause notice, this is just to asking him, my lord, to confirm the discrepancies.
You have challenged the virus of the rules
Yes.
of 2016.
Yes. Well, may I show the
Do you have a copy of my order?
yes,
Hard copy.
Lordship's order I don't have because but there is one order I have. Lordship also earlier occasions without giving too much of detail passed an order that I have.
Just
But
yes, it is not uploaded in
Lordship
the
may
server.
kindly take it. It is yet to be uploaded.
That's no, it is not uploaded. It is with me. Just
But I am told that the similar order would do.
yes.
And it is my lord, all the
It is show cause notice dated 4th July.
yes, 4th July. And I also gave my reply also on 12/8, and but that is a technicality part.
I say, my lord, this is not a show cause to termination, my lord.
Hitesh Kumar Goel matter is pending before the Honorable Supreme.
Yes.
Yes.
In all matters, this Hitesh Goel matter, last order, you have to supply because it is being taken on record as in the previous matter.
Yes.
What more is else is required? Come to page 50.
All have.
What you are submitting?
This my
If
lord,
no reply is received within the stipulated period, further action will be taken.
further action will be taken, my lord. That action, my lord, is a show cause to termination which is amendable.
That is generally the part of the show cause notice.
My lord, this is just to, my lord, the
Suppose a petitioner gives a reply. Of course, he has given a reply, I believe. Then if it is not satisfactory, you are in a position to invoke the relevant provisions of 16, which is under challenge.
That is, my lord, the show cause to termination, my lord. Then he comes.
Esho.
And my lord, only one more thing, my lord.
No further, sorry.
Only one more thing, my
enough
lord,
is enough.
because this, my lord, is becoming burdensome on the exchequer, my lord, public exchequer.
Yes, yes.
He has, my lord,
Already
himself
other
admitted in the page
courts have
51.
passed similar order, including division bench of our court.
There are several.
No, এটা same order করবে 4th July 2025 এর যে এই যে শো কজ নোটিশটা ডেটটা মনে হয় ভ্যারি করবে। হ্যাঁ অনেকগুলো মনে হয় সিমিলার অর্ডার আছে 4th July 2025 এটার ক্ষেত্রে হবে এটা 14 July চলে হবে একটা সেম অর্ডার। নেক্সট But I have given a liberty that to mention the matter if the situation is altered by virtue of the order of the Supreme Court.
And my lord has given us an opportunity to file the affidavit in opposition.
No, it will appear under the heading motion in the monthly list of February.
My lord, by that time the affidavits can be exchanged, my lord. At least the matter will be ready for hearing.
If the issue is decided, what affidavit is required by the Honorable Supreme Court?
My lord,
Let us see up to February what order comes from the Honorable Supreme Court.
But my lord,
But if the order is passed by the Honorable Supreme Court changing the present situation, you mention the matter. I have given liberty.
if you're waiting,
All matters affidavit is not required since the court is in session. Supreme Court top court is in session of the matter. Yes, same order.
Item number 5.
7, my lord, are similar matters.
Yes, I think this show cause notice date is different.
Only the show cause, the point
Where is
that,
the show cause
that
notice?
point that I was on, my lord, 4 to 7 are similar show cause notices.
Yes, where is the show cause notice?
Well, item number 4, my lord, page 51 is the show.
51, just.
Item number 5, my lord. Wait, my lord.
Item 549.
Item 5, it is a show cause notice.
49 page. That page 49.
49, my lord.
19th August 2025 show cause notice date. বুঝতে পেরেছো? ওটা চেঞ্জ হবে 19th August. Otherwise, rest of the order will remain same.
June 25th for the next one.
Item number
Yes.
For the next one, June 25th.
Yes, let it be placed. In all matters, you will supply the last order of the Supreme Court, which is taken on record as I have noted, recorded in my previous order on 6 November, passed on 6 November.
Yes, I'll do it.
Yes, page 49.
49.
This is 25th June 2025. 25th June 2025, page 49. Same order.
Item number 7.
You initiate your proceedings. There is no stay to that.
Proceedings,
You take steps.
Told me, sir. It do to us. 7, 8.
This is page
Page is not
page
legible.
51 perhaps. Come to page 51.
51.
20th June 2025, page
20
51.
June 2025, 51.
20th June 20 June 2025. Same order.
Item number 8.
And my lord, this item 8, my lord, is exactly, my lord, what I was submitting because after that notice to confirm the discrepancies, we have issued another notice, my lord, show cause for termination. So there, my lord, technically there will be 2 show cause notices, but they have challenged one because this is subsequent to the filing of the writ petition.
Item number 8, my lord.
So the initial show cause notice court is also taking into consideration, because that is the point from where
Initiation of
the
the
proceeding is initiated. Now you carry on your proceedings,
Very well.
but don't pass final order.
Without the leave of
Yes, yes. Where is the first show cause notice?
first show cause notice is at page 54.
54.
4 of the writ petition.
Followed by, my lord, another in a supplementary affidavit affirmed by.
My lord, second show cause notice, my lord, was issued to me, my lord, during pendency, my lord, after affirmation, not after filing, my lord, after affirmation. I, my lord, prepared a supplementary affidavit, my lord, to bring that on record. Copy has been served upon them.
আচ্ছা, তাহলে এটা শো কজ নোটিশটা 14 জুলাই 2025 করো। স্টপ করে সেম অর্ডার করে দেবে, তারপরে নিচে অ্যাড করবে learned advocates representing the petitioner and Life Insurance Corporation of India Limited in Life Insurance Corporation of India have jointly submitted that subsequently another show cause notice has been issued. What is the date of that show cause notice?
October 7th.
7th of October 2025.
Another show cause notice has been issued against the petitioner in the month of October 2025, which is not part of the record. Stop. Leave is granted to the learned advocate. Leave is granted to the petitioner to file a supplementary affidavit by 7 days from date in order to bring.
Ready. Supplementary.
তাহলে তো এটা লেখা দরকার নেই। কি বললাম সেন্টেন্সটা একটু বলো। এটা দাঁড়াও, তাহলে এখানটা এই অবধি একটা তো করলে 14 জুলাই দিয়ে নোট করে নাও, তারপরে এরপরে এইখানে একটা প্যারাগ্রাফ অ্যাড করে দেবে। It is submitted by the learned advocates representing the petitioner and Life Insurance Corporation of India that another show cause notice was issued on 7th October 2025. Stop. Enclosing the said show cause notice dated 7th October 2025, a supplementary affidavit is filed today, which was affirmed on 4th October. Which was affirmed on 4th November 2025, and same is taken on record. Stop. তারপরে rest of the matter order will be.
Just something for my lord's attention only, not for the my lord record. If my lord takes up page 54 of the writ petition.
54, yes.
My lord, why I was objecting to this interim orders, my lord. Someone who has to prescribe to a cost ratio of 19%. Someone who has to abide by a cost ratio of 19%, my lord, has performed a cost ratio of 1500. By virtue of this interim orders, my lord, they have stopped performing, my lord. It's a difficulty that we are facing, my lord.
Yes, you go on with your proceedings, but with regard to the validity and legality of the provisions of 2016, which is stayed, and which is before the whether the constitutionality of those relevant provisions of 2016 is before the Honorable Supreme Court. So you need to take it into this aspect in mind. So that's why at this stage, if the matter is decided on merit, then everything goes.
No, I understand.
Yes, so that is the main issue.
I'm equal to my lord.
There may be merit in the proceeding which has been initiated against the petitioner, but whether in the matter of initiating and concluding proceeding, whether the LIC can take refuge to the relevant provisions of section of 2016 rules. That is the issue
That
which
is
needs
issue
to be
pending.
decided.
It's a good point.
Yes.
Great.
Give supply copies of the Supreme Court order. Yes. You know, affidavit of service. Yes, call the next matter.
Item number 9.
I am for the respondent. In terms of your lordship's last.
Just a minute, affidavit of service. File. Yes. Place your case.
Lord, all the petitioners before your lordships, my lord, participated in the selection process of 2024 for the constable, GD, and CRPF, CAFF, combined examination conducted by the my lord, Staff Selection Commission, Eastern Zone. But all these candidates will cross all the hurdles that PST, PET, all the examinations. Thereafter, their name featured in the final merit list. But when the final merit list, my lord, published, their name has been placed in the my lord, withheld merit list. My lord, for withheld list, my lord, there are reasons for withheld, my lord, for CFSL, my lord, or my lord, biometric mismatch, all these things for my lord, DIG, my lord, CRPF, my lord, place those candidates in the my lord, withheld list, withheld merit list. My lord, some of the candidates has already been already given appointment in the
From this withheld merit list.
Withheld merit list. My lord, as of now, this is my instruction that all the CFSL authority and the handwriting authority has already cleared the names, all the candidates
Of the petitioners.
present petitioners. Now it is pending before the my lord, SSC.
SSC.
Staff Selection Commission.
Staff Selection Commission.
All it is pending before the my lord, Staff Selection Commission. This is my instruction.
Yes, my lord, friend is true, correct.
So if the objection,
no, my lord,
was raised,
question is, my lord, to my instruction has already been. I have received instruction.
if the objections are not sustainable and it is cleared by the concerned authority, then why the petitioner will not be favored with appointments?
The question is, my lord, CRPF is the nodal officer, DIG. So CISF, it has been cleared. I have received the instruction. But in the cases of BSF and CRPF, my lord, I have not.
CISF cleared.
CISF
from
cleared.
the withheld list.
Withheld list.
But BSF and
CRPF, I have not yet received the instruction.
BSF and
CRPF.
CRPF.
My lord, I have not yet received the instructions, my lord. So,
yes,
my lord, on those cases, my lord, I cannot.
So there is a common panel for CISF, BSF, and CRPF.
Yes.
For the post of Constable GD.
Yes. But CISF, it is clear. I have received appropriate instruction that they have been, the CFSL report is in their favor.
You are representing which authority?
Union of all the respondents.
So then why you have not taken instruction?
Well, I have asked for instruction, but till date I have got only one. So I have asked for that instruction.
My instruction, it has been cleared way back in the month of
Very well,
September.
come back on next Monday and file a report in the meantime.
My lord, can it be
yes,
tomorrow around 14 to 21 I will be absent from court because of my personal difficulty. So if it is possible, my lord, I am praying only.
Then come back on coming Thursday.
That can
on obtaining instruction. You need not file report on obtaining instruction.
My lord. If
these candidates from the panel of candidates who are found to be withheld candidates. If these candidates are now cleared by the concerned authorities, then there is no embargo or there is no impediment in appointing the petitioners.
Yes. And finally, I presume from their discussions that all have been cleared. But unless I get the instruction,
and
yes.
come back.
So that's what
Further
I was.
So in
But
terms of
CISF, it is
because but the petitioners are not for CISF constable,
BSF and CRPF.
BSF and CRPF. In terms of the order dated 3rd November 2025, court fee has deficit court fee has been or court fee has been court fee was deposited, and in support of same a document is filed today and same is taken on record. Next paragraph. Learned advocate representing the petitioners submits that names of the petitioners are featuring in the panel of withheld candidates, comma, panel was prepared for appointment as Constable GD in Border Security Force and Central Reserve.
This is a combined common examinations. It is for the post of constable within bracket GD in CAPF. Paragraph
SSB কথা বলছো তো?
paragraph 2 page 7 paragraph 2.
কি বলছিলেন? For appointment of Constable GD in various central discipline forces. Stop. It is submitted on behalf of the petitioners that on being cleared by the concerned authorities, candidates were appointed as Constable GD. Some of the candidates from the said panel were appointed as Constable GD in CISF.
In different CISF, BSF, CR.
Cleared candidates were appointed as GD in CISF.
In different
So you are submitting that for CISF, it is already the appointment.
there are three authorities. CISF, BSF, three authorities will
And then CRPF.
Conduct these examinations.
SSB is also there.
Submission CIFS are already clear. So far the BSF and CRPF is concerned,
And
they have not
SSB.
received instruction.
So that is why I am recording that the candidates who are to be appointed as GD in CISF, they are already favored with appointment. So what is the wrong in such recording?
CISF there is no wrong. But so far other parts.
কি বলবো মুশকিল বলো
Sorry.
SSB candidate, SSB may kindly be included.
Yes.
SSB, সীমা সুরক্ষা বল।
হ্যাঁ কি বলছিলেন? In CISF, it is also contended that similarly circumstanced candidates whose names are featuring in the list of withheld candidates and are to be appointed as Constable GD in BSF and CRPF till date are not favored with appointments, though petitioners are cleared by the concerned respondent authorities. Next paragraph, Mr. Bajpayee, learned advocate representing Union of India, prays for accommodation to obtain instructions whether the candidates whether the petitioners whose names are appearing in the panel of withheld candidates can be appointed in BSF and CRPF or not. Stop.
SSB.
Next paragraph, list the matter under the same heading for further consideration on Thursday. On Thursday next. Thursday next. November 2025. Come back. Issue. এটা কত নম্বর হলো গো? 9 Yes, for the list.
Item number 10.
I am appearing for the petitioner. Well, it is with regard to Constable GD. My lord, kindly peruses my lord's last order dated 3rd of.
Lordship, item number 10, Lordship, Mr. Bojis paying for the respondent Union of India, Lordship. As a lying in Lordship, kindly 1 day accommodation is only not today, Lordship.
But to file a
I'm
report
paying for only
Well,
Lordship.
not today. Come back to me.
Lordship.
Item number 11.
Item number 11, I am for the petitioner, Lordship. Lordship, in this matter, Mr. Advocate Mr. Shomu Mujumdar is appearing as a petitioner, Lordship. So I am just praying for short partial, Lordship, because he is engaged in.
You are appearing for?
For the respondent, I'm led by Mr. Kaur.
Which respondent?
For the High Court administration.
Whether on 12. Next.
Item number 12.
My lord, I am just indulging.
Come back again.
My lord,
Before 791.
Next.
yes, my lord, I am for the petitioner.
No, I am for.
Lordship, recollect that Lordship has asked me to produce a judgment of Kajol Pal passed in. Now, this is the Durgapur Project Limited matter where Lordship interest over the interest on gratuity and leave salary.
Yes,
I
yes.
rely on a judgment. That judgment was passed on rely upon a judgment passed by Justice Arindam Mukherjee in Kajol Pal, Lordship. The Lordship want to see the judgment of Kajol Pal.
Take it out. What you are claiming interest on gratuity?
Gratuity and leave salary both. Lordship, in page number 11, 12 and 13. On the basis of 12 and 13, 11 was issued. And page number 14 is the proof of payment.
Now, where Kajol Pal order was referred to?
My lord, earlier occasion I referred to a judgment. My lord, that last
That is what I'm trying to. Yes, 24th September 2024 order.
Yes.
Yes. কবে রিটায়ার করলো রে?
এটা 25 ফেব্রুয়ারি 25 পেজ 11
পেমেন্ট করলাম কবে আমরা? ফেব্রুয়ারি।
পেমেন্ট
তো তাড়াতাড়ি
respondent. Huh?
হ্যাঁ ওইটাই। Yes.
Now, on payment of leave salary and issues pending before the Supreme Court.
That was Milord pending. But so far,
Krishna Prasad Chatterjee's matter.
yes, yes.
So what was the order passed by the Honorable Supreme Court?
Milord, that I have not yet, Milord, searched out, but that cost.
Now, this Kajol Pal, in Kajol Pal's case, there was a consensus in between the parties to the extent of 6% from the date following the date of retirement till date of payment.
Till date of payment.
Till date of payment. And that consensus is also recorded in the order passed in Vishwanath Dham, which is relied upon by the petitioner.
Milord, that was there.
Today, whether this court can record consensus.
Milord, that is there. But your lordships kindly consider, Milord. So far, Durgapur project is concerned, your lordship, Milord, it's my request. Milord, the condition is very poor. Milord.
Maybe, but that was considered by the court. Their financial stringency.
Milord, it's very, now, Milord, day to your lordship knows, Milord, the distribution system has already, Milord, went to the WSCDC.
You have not preferred appeal against this order of the coordinate bench in Kajol Pal.
No, Milord, that, yes, that.
Then,
was,
how these points can be agitated, which have already been decided in Kajol Pal?
That, Milord, I'm.
And there, this point was taken. The respondent said that the delay in payment was not intentional, but due to financial
crisis. Milord. Financial crisis is there, Milord. That is why, Milord, otherwise.
Let me record, as it was recorded in case of Kajol Pal and Vishwanath Dham, that 6% there is consensus. So far, 6% interest is concerned on
gratuity,
retirement dues, gratuity, and leave salary. Leave salary, but there would be a default clause that if you
yes, that is there.
Then 10 statutory interest will be attracted.
But may I?
Yes.
If your lordships kindly consider some, Milord, financial condition is very poor, Milord. Let it be, Milord, 5% and
no
8 months.
Now tell me the date of your retirement.
Yes, Lordship. Date of retirement is noted at page number 11, Lordship.
Tell me the date.
28 February 25, the first matter.
So you are entitled to get interest from 1st March 2025. When payment was made?
Payment was made on, Lordship, 25th August 2025.
Milord, 1st March, Milord, 1 month is statutory period. Your lordships kindly consider. After retirement, 1 month is statutory.
For payment?
Yes.
So then 1st April.
1st April.
1st April 2025 till payment?
Till, Milord, payment is
25th August 2025. But my
yes, 25th August.
So you are entitled to get up to 24th of August 2025.
May I submit one thing?
Yes.
Lordship, in Kajol Pal also, it was directed to be paid from the next date of the retirement. But in every judgment.
Yes, statutory period may be 1 month.
1 month.
1 month, but if you fail to pay, then this 1 month will be included.
But, Milord, the subsequent order, Justice Aniruddha Roy has considered, your lordships kindly see. Justice Roy has considered, yes, after 1 month.
No, my lord, but I have the latest judgment.
Yes, yes. আমি Aniruddha Roy judgment বলছি. After 1 month, each and every order, Justice Roy has mentioned, Milord, kindly consider.
There is no order passed by Justice Roy before me.
Yes, Lordship, I have
Aniruddha Roy, they order to this. That was the last order.
That was the last order, Lordship. Kindly see.
So many order passed to different court.
My lord, first page retired on 25th August. The payment on the 25th August.
31st January has retired on 31st January 20 and Justice Roy has directed from 1st February. So 1 month period has considered. না না এটাই দিয়েছি তো আমি দিলাম তো একই অর্ডার প্রত্যেকটাতেই তাই করেছে I am not bargaining with the court, why not? I am just
No, Justice Rai has in Sukhomoy Bhui, it is directed that
After 1
6% per annum within a period of 6 months from the date of communication of the server.
no, my lord.
Copy of this order without insisting upon production of a certified copy of the certified copy thereof, and in default, statutory rate of interest at a rate of 10% per annum, as in the case of gratuity and leave salary, will be attracted.
Entire amount from
1st of March.
Yes.
28 February, 1st of March. Next date.
After one.
Where is the direction that 6% interest is to be awarded to the petitioner from 1st April?
No, that's not that. After 1 month. I'm saying after 1.
Not after 1 month. Petitioner retired in the case
31st.
Sukhomoy Bhui 28 February 2025. Petitioner retired from service on 28 February.
No, my lord, that was initial order. Subsequent order, the petitioner retired on that was corrected. January 31st, 2020. I'm submitting, and his lordship was directed to make payment from 1st February 20.
What is the date of this order?
This order, my lord, 24th September 25.
Yes, I am on 25th September 2025 order. Where is the correction?
No, page 2 from February.
This is not the same case, my lord, perhaps.
No, maybe.
Not from, it is recorded in first page that petitioner retired from service on 28 February 2025. Then it was directed that payment of interest, respondent is directed to pay interest on the principal amount of gratuity and leave salaries so and so at the rate of 6% per annum within a period of 6 months from the date of communication of the server copy of this order without insisting upon production of certified copy, and in default statutory interest 10%, as in the case of gratuity and leave salary, will be attracted on the entire amount from 1st March.
Yes.
That is the next date.
Next following month.
No. 28 February retired, direction from 1st of March. What following month?
Yes.
From the date following the
February.
next day, following the date of retirement.
March.
What you are submitting?
March. Till March.
Don't make wrong submission.
No, I am not. After 1 month, following date, next. Similar to one request, people, lordships kindly consider the time may be extended. Because huge financial crunch is there.
What is the total amount which was paid?
Yes, my lord. Total amount was paid to me on 19,51,000.
Where you have stated?
My lord, page 11. Page 11 is the document.
Yes, page 11. Just a minute.
Page 11. Page 11 is the bill, lord.
Yes, 1951,339.
329.
No, 339.
10 rupees has been deducted. Kindly see. Bottom.
Less deduction.
Yes.
51,329.
Deducted.
29.
Yes.
Well, a period maybe
6 months period directed.
That is, it's my submission because huge financial crunch is there. If your lordship consider.
Petitioner affidavit of service agei file kore diyeche.
Yes, I sir.
Petitioner was an employee of Durgapur Projects Limited who retired on superannuation on 28 February 2025. It is submitted by the learned advocate representing the petitioner that on calculating retirement dues of the petitioner, towards gratuity and leave salary, total rupees 1951,329. 1951,329 was paid to the petitioner on 25th August 2025. Stop. Petitioner claims interest on delayed payment of gratuity and leave salary. Stop. Stop. Petitioner has relied upon order of coordinate bench passed on WPA 11485 of 2021 within bracket Sri Kajol Pal versus the Durgapur Projects Limited and others close bracket. Ninth August বললাম তো petitioner has বলো সেন্টেন্সটা বলো dated 9th August 2021 wherein the coordinate bench directed 6% interest to be paid on deferred payment of retirement dues within a specified time. Stop. However, such order, stop. Nah, কেটে দাও, stop. Petitioner has also relied upon judgment of another coordinate bench dated 24th September 2025 passed on a writ petition being WPA 22031 of 2025 within bracket Sukhomoy Bhui alias Sukhomoy Bhui versus Durgapur Projects Limited and others. Close bracket. Next paragraph, learned advocate Durgapur Projects Limited has submitted that no appeal was preferred against order dated 9th August 2021 passed in Kajol Pal Supra and judgment dated 24th September 2025 passed in Sukhomoy Bhui Supra. However, it is contended that Durgapur Projects Limited is reeling under shortage of fund, as a result whereof timely payment of retirement dues could not be made to its retired employee, to its superannuated employees. Next paragraph. Having considered the submissions made on behalf of the parties and taking note of the orders passed in Kajol Pal Supra and Sukhomoy Bhui Supra by two different coordinate benches, it appears that in both the cases, Durgapur Project Limited was directed to pay 6% interest on deferred payment of gratuity and leave salary
within 6 months.
Within a specified time, failing which courts further directed that respondent authority was required to pay statutory rate of interest on such deferred or statutory rate of interest on dues now on such deferred payments. Next paragraph. It is next paragraph. It needs to be recorded here that though petitioner retired on superannuation on 28 February 2025, payment towards gratuity and leave salary was paid on 25th August 2025. As a result whereof, respondent authority was benefited financially. Stop. As the petitioner is entitled to receive retirement dues on the next date following the date of his superannuation, comma, petitioner is entitled to receive interest on deferred payments. Next paragraph. General manager is to be directed.
No, Milord. Durgapur Project Limited is directed.
Concerned authority of Durgapur Projects Limited is directed to pay 6% interest per annum on rupees 1951329 within a period of 6 months from the date of communication of this order.
Lord, may it be 8 months because now, Milord, day to day we are financial.
Within a period of 6 months, sorry. Within a period of 6 months from the date of communication of this order, for the period from 1st March 2025 till 24th August 2025, failing which concerned authority of Durgapur Projects Limited shall be liable to pay statutory interest of 10% on such deferred payment on the aforesaid amount for the period from 1st March 2025 to 24th August 2025,
After 6 months.
stop. Writ petition stands disposed of urgent xerox.
Petitioner shall be given liberty to submit, communicate this order with the server copy of the.
Give some time.
Grateful to you.
No. Server copy you can always communicate.
Nowadays, Milord, authorities act on the basis of server copy. Item number 30, they will not wait for certified copy.
Same matter. At page 11.
Now, what is required? The amount first.
Page 11.
11.
Page 11, 13,66,088.
Page 11, just a minute. 13,66,088.
Yes.
Thirteen 66,088.
Date of retirement is 31st January 20.
Just a minute. Retired on 31st
January.
And payment made on
26 July, June. No, January, February, March. 26 June 2025.
then petitioner is entitled to receive interest for the period from 1st February 2025 till 25th June 2025. এসো একটু বুঝে নাও ব্যাপারটা। প্রথমত অ্যামাউন্টটা যেটা হবে এসএম অর্ডার হবে, অ্যামাউন্ট যেটা হবে সেটা 1366,088। এবারে রিটায়ারমেন্ট ডেট হচ্ছে লিখে নাও 31st January 2025। Payment date 26 June 2025. Payment of interest for the period from 1st February 2025 to 25th June 2025. মাথায় গেল তো? সাজিয়ে নেবে। থাক ওই পর ওই ম্যাটার দু একটা ম্যাটার আছে। Disposed of?
Yes.
Item number 14.
Number?
Page 11.
Yes, page 11.
Amount.
Amount lordship 24,37. Yes, 24,37,682.
Retired on?
Retired on 31st January 2025.
So 1st of February 2025 onwards you will get.
My lord,
And payment made on?
payment on 30th July 2025.
30th July
Yes.
25.
Yes.
Shono. Then up to 29th July 2025.
Yes.
29th June.
July.
July. 30th July.
Amount is 24,37,682.
July.
করে নিয়েছো? 24,37,682. Retired on 31st January 2025. Payment made on 30th July 2025. Period for which petitioner is to receive interest on gratuity is from 1st February 2025 to 29th July 2025. Rest of the order remains same. Yes, disposed of.
Item number 15.
এটা তো page 11 না?
Yes, amount
14,51,000.
page 11.
11.
For 1451,839.
Yes, lordship. Retired on?
Just a minute, just a minute. Yes, retired on?
February 2020, 28 February 2025.
28 February 2025.
Yes.
And payment on
25th August 2025.
25th August 25.
Yes. 1st March 2025.
1st March 2025 to 24th August 25. এসো অ্যামাউন্টটা লিখে নাও 1451,839. Retired on 28 February 2025. Payment made on 25th August 2025. Period for which petitioner to receive interest 1st of March 2025 to 24th August 2025. Is disposed of. Affidavit of service.
I am giving.
আচ্ছা প্রত্যেকটাই এগুলোতে আগেরটাই নেই affidavit of service filed on behalf of the petitioner is taken on record. File your affidavit of service.
Yes, sir.
নিয়ে নাও।
প্রথমেরটা দেয়া ছিল বাকিগুলো।
Yes.
মানে ফার্স্ট ওয়ান
আগের দিনেই বলাই দিয়েছি। Item number 16.
মানে page 11.
Page 11. 2031145.
Yes.
Retired on.
Subject to your lordship correction at page 11, date of retirement is written as 31st January 2024. It should be 2025. That is confirmed as page 13. Kindly see.
It's a typographical.
By page 13, my lord, last line.
31st March 2025.
31st January.
31st January 2025.
That was wrongly printed. I admit that.
Instead of 2024, it is 2025. Payment made on?
Payment made on 30th July. July 30, 2025.
From 1st February 2025.
From 1st February 2025 till
29 July. Issue 2031145 amount. করেছো? আচ্ছা, retired on 31st January 2025. Payment on 30th July 2025. Period is from 1st February 2025 to 29th July 2025. Disposed of. Filed affidavit of service. Next.
Item number 17.
Next one is slightly different. Let me submit, my lord. Slightly different, lord.
My lord, we have make payment before my learned friends. We have make payment with interest. Now, due to my lord and ROFA, this was my lord additional gratuity and leave salary was paid. Due to my lord ROFA, the DA component and all this things. Now my
Which ROFA was in
ROFA 20.
ROFA 20.
Now my learned friends, my lord, clients is paying interest also, my lord. This amount, this should be your lordship's kindly cost.
Why not?
No, this your lordship.
You tell me from which date petitioner is entitled to get interest due to revision of pay?
Yes.
Under ROPA 20, tell me.
No, my lord, I am not bargaining with the court. Considering the
Why not?
situation, your lordship kindly consider. We have already paid with interest.
Similar issue.
Yes, similar issue.
Whatever petitioner is entitled to get, that petitioner should be paid on the date following the date of return.
No, that is
or on the date of return.
No, I am not disputing due to financial.
If ROPA 20 was implemented after that implemented after delay, or there is a delayed implementation of ROPA
it's a delay.
2020,
It's a delay.
why petitioner will suffer?
No, my lord, it's a delay. But due to my lord financial crunch, your lordships kindly consider, my lord, it's a heavy financial crisis.
Same
is
issue.
there.
Same issue.
But my lord, we have already paid interest. Your lordships kindly consider, my lord, again. Then my lord, another 2,000-3,000 employees will be there. My lord, the
Yes.
floodgate will open. My
Yes.
lord, your lordships kindly
So
consider.
if it is their right, if floodgate will
No,
open, okay.
actually, I am not.
If it is their right, you have
Well,
to
it's
make
a
payment.
it's a submission before the court. I am not, my lord. I am not.
But
Okay.
it does not cut any eyes, because whatever petitioner is entitled to receive, petitioner will get it. If there is deferred payment, you have to pay interest. Tell me, many things are being said on financial stringency. Tell me that the existing employees' salary is being reduced. Show me.
My lord, with due respect.
I know.
My lord, with
I used to appear on
Yes,
behalf
yes,
of
your
similar
lordship knows,
organization.
your lordship
It is
knows.
very much known to
Your
me.
lordship knows. My lord,
Yes. So therefore, tell me that
with due
existing
respect,
employees
with
who
due
are
respect.
working, their salary is
has
being
been
cutted.
deferred. Yes, my
Yes.
lord, it is being deferred.
Yes.
And my lord, that's why number of employees.
Any instance,
Kindly.
any instance
Kindly.
that higher official working in Durgapur Projects Limited is not getting salary as per the revised rate.
No, I'm not saying. My lord, kindly consider, most of the employees has already been transferred to the WBSC TCL, DPA, PDCL. That is why.
Very good.
At least, my lord, more than, my lord, 1,500 employees already been, my lord, transfer from this organization to that
So
organization.
there is no existing employee.
Existing employees there.
Are there?
Yes.
So in case of existing
Well,
employees,
the payment was deferred
there-
payment. Yes.
is there
Crisis
any-
is there.
In case of existing employees, is there any instance that they are not being paid
No.
within?
That's what I cannot. Deferred payment is there. Even, my lord, the salary was also deferred. Sometimes, my lord, 10 days.
They will get arrears.
10 days, 15 days because of the financial crunch. Now I leave it to your lordship. My lord, that is, my lord, by submission. That's the, my lord. I am not.
If you can show that existing employees' payment is being curtailed,
it is being deferred.
due to
It is
stringency,
deferred. It is.
you will never find it.
Yes. No, it is deferred.
You will never find it. I am telling you.
No, yes. There is no curtailment of the salary, my lord, but it is being deferred.
Shall I direct to file an affidavit disclosing your assets and payment mode of making payment to the existing employees and officers?
Well, that, affidavit I can,
Then
showing
you
the
difficulty.
My lord, showing, my lord, the income tax return, my lord. That's no difficulty.
Then-
That I can show to your lordship.
Then tell me. So therefore,
for last 3 years.
as per ROPA 2020, there was a deferred payment.
Deferred.
So was there any issuance of revised pension payment order?
Well,
How this deferred payment
pension
was
is not there, my lord. The Durgapur project
not
limit.
pension but revised retirement dues.
Yes. That is there, my lord.
At the
That-
time of retirement, there was a payment. But now there was a delay in implementing ROPA 2020.
Page 8.
Now, in view of implementation of ROPA revised pay scale, or in view of consolidation of pay of the petitioner and pension of the petitioner, was there
There is
any
no pension.
any or consolidation retirement dues of the petitioner, whether any subsequent bill was raised or issued for payment
Subsequent
or
order.
consolidated bill?
Subsequent order was issued.
So where are those orders?
18.
Page 19.
Page 18 and 19. my lord.
Page 18 is the common, my lord, common direction for ROPA, implementation of ROPA, page 18. And page 19 is the order of the petition.
Newton leaves something.
তোমার সাহেব যা করবে কি করা যাবে না ওটা তো তুই ভুল করে হয়ে গেছে দ্যাট ওয়াজ নট উইথ
শুভেন্দু এসছে তো? হ্যাঁ, তুমি চলে যাও। When it was paid,
Third one.
differential amount?
Yes, differential amount, page 24.
24th May.
My lord, here amount is different because, my lord, may I submit? My lord, leave salary and gratuity.
Please tell me when it was paid.
My lord, 24th
May.
May 2025.
Check is at page 20.
Yes, my lord, page 20.
So from which date you are claiming interest?
It should be from the date of implementation of the.
Demonstrate it.
It
You
should
have
be-
to rely upon the relevant ROPA 2020, which was required to be applied from a particular date. There will be a stipulation. There must have been a stipulation in ROPA 2020.
My lord, kindly.
Because court has to award interest specifying the period. So in order to pass such order, you have to show that this ROPA 2020 was required to be implemented from a particular date as per the relevant provisions of ROPA 20. Where is such provision?
Subject to your lordship permission, their own notification, page 18, kindly see.
That I have seen.
Those
But ROPA 2020 you have to show me. In order to derive a conclusion that yes, petitioner or the retired employee is entitled to get interest due to revised benefits towards gratuity and leave salary from a particular date.
Not today's time.
Issue.
Grateful to your lords.
Otherwise, court will not be able to pass an order indicating the period up to the date preceding the date of payment. That is, you are entitled to get interest up to 23rd of May 2025. But from which date? That you will find answer from the relevant provision of ROPA 2020. Petitioner, file your affidavit of service.
Already filed.
Petitioner is employee of Durgapur Project Limited and has retired on superannuation. Stop. It is submitted. Retirement benefits of the petitioner has been or was revised, was upwardly revised in terms of revision of pay and allowance rules 2020. As a result whereof, petitioner was paid revised. Petitioner was paid
ROPA 20
benefits or retirement. Petitioner was paid revised retirement benefits, adjusting the payment which was initially made prior to implementation of ROPA 2020. Stop. Prayer is next paragraph. Prayer is made for giving direction upon the concerned authority of Durgapur Project Limited to pay interest on revised benefits. Stop. Next paragraph. However, it is not shown before this court on behalf of the learned advocates representing the petitioner and Durgapur Project Limited that from which date petitioner was entitled to receive revised benefits as per ROPA 2020. Stop. Next paragraph. Learned advocate representing the petitioner and Durgapur Project Limited have prayed for accommodation to obtain instruction and to produce ROPA 2020 on the next date. Stop. Next paragraph. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration on 24th November 2024. Next. Item number 18.
Respondent in this matter, my lord.
Well, I beg to appear on behalf of. Well, it was adjourned on the last occasion. It was my fault that I didn't bring that revised uniform guideline or revised uniform guideline. Now, my lord, these pertains to the selection process of, my lord, various groups of, my lord, CRPF, Assam Rifles, several groups. Now, my lord, at the entry level, there is a computer-based test. Subsequent to the computer-based test, CBT. Now, my lord, subsequent to the crossing that hurdle, my lord, there is a height measurement process along with other chest and height measurement process. Now, my lord, in my respectful submission.
Yes, whose mobile is ringing?
In my respectful submission, my lord, the medical.
What you are praying for?
My praying for is that, my lord, at the threshold, I have been, my lord, disqualified in spite of having a measurement of 169.5. Now, my lord, there is a.
So you are praying for rounding off to the next higher digit.
Yes.
69 point.
If I cross 69.5, then, my lord, I'm automatically, my lord, counted at 70.
70.
Yes. This is my respectful submission. Now, my lord, on the last occasion, my lord, the rules were not with me. So, my lord, I have brought the rules today. The general instruction for recruitment board. My lord, may I hand over?
You are appearing for the respondent.
Respondent, my lord. My lord, Ajit Chobe and me, my lord.
My lord, the clause starts at it's clause 2D. Measurement of physical standard, height, weight, and chest is the responsibility of, my lord. May I skip this over?
Clause.
Page 3, my lord, is looking at page 3.
103.
103 is, my lord, marked by me. My lord, kindly ignore that inner page 3 of the circular. It's bottom. It's bottom in the same page. The lordship is absolutely
The page, this page.
103 is on the top.
Yes.
But the departmental circular page corresponds to page 3. That is at the bottom.
Page 3 from the beginning?
No, my lord. The circular starts at
same page, page 103.
104.
104.
Yes. What happened, my lord? I may be ignored, my lord. This was a part.
Which clause you are relying upon?
I am relying upon 2D.
2D. There is no 2D
My
in
lord,
page 103, 104.
No, my lord. It's page 3, inner page 3. May I just, my lord, may I take back and hand it over?
Just a minute.
One second. Your lordship sees that the bottom
measurement of physical standard, namely height, weight.
Yes.
Yes, just a minute. Place it.
Grateful, my lord. For all categories of candidates, such and such, medical officers will not be the part of PST board, both for
measurement of physical standards, namely height, weight, and chest, is the responsibility of the
PST board. Yes.
Standard test board for all categories of candidates. Yes.
Recruitment medical officer will mention physical standard in the medical examination form as recorded by the PST board. In borderline cases of overweight, BMI should be considered to be arrive at a conclusion at the variation of 5+ kgs.
Just a minute. Stop. Yes, it says that similarly, while measuring height fraction of centimeter less than 0.5 will be ignored, and 0.5 centimeter and more will be rounded up to the next higher centimeter. Standard height weight chart is attached.
That is annexure.
So where is your measurement of height, which is part of record?
My lord, প্রথম রিডটা কোনটা? এটা page number.
Yes, page 18, 169.5. If it is 170, you will come within the zone of consideration.
Yes. My lord, to that effect, my lord, if your lordship permits me, the coordinate bench has also, my lord, decided on this issue. I can, my lord.
So why, what is your instruction? Why it will not be rounded off to the next higher centimeter or higher digits?
My lord, it is correct, my lord. The parallel bench has been, my lord, decided that it's rounded off on 170, my lord. My lord, as per instruction, there is an appellate forum, my lord. After passing this order, my lord, there is appellate forum, and after appellate forum, after coming within 24-hour appellate forum, there
You have not paid for review measurement.
If I come within the zone of consideration, suppose, my lord, with due respect, I go before the appellate forum.
No, but everybody is preferring review.
Yes, because those who are below that, my lord, 169.5, they are preferring a review. My lord, if the rule permits me, I
No,
need
but
not-
in the review also it can be corrected.
No, in the review it may be, suppose, my lord.
It may be,
Yes,
but if there is
there
a
has been
provision for
instances.
review, yes, like in medical cases relating to medical parameters,
Yes.
there also everybody approaching the court after review.
I am aggrieved by the measurement. I am not aggrieved by the measurement. The
No,
measurement.
169.5.
Yes.
You can prefer a review before the reviewing authority
Yes.
based on the strength of 3D.
Absolutely. But suppose, my
So if you are aggrieved after the after the review order, you can come. But if there is a review provision, why you are coming at this stage?
suppose, my lord, we assume a situation where in the review board measures my height.
Why
as
court will
69.5.
presuppose?
Yes. No.
Why court will presuppose at this stage when there is a provision?
The review-
Suppose a case of disciplinary proceeding.
Yes.
Somebody is dismissed from service.
Absolutely.
And there is a order of the dismissal order by the disciplinary authority.
But my
And there is a provision for review. So whether the court will interfere at this stage, unless there is a glaring violation of principle of natural justice.
may I
So it is
read
not a case of violation of natural justice.
May
You
I-
are aggrieved by the measurement. If it is 169.5 and if you are declared not eligible or ineligible, then now the remedy lies before the reviewing authority. Go before the review, and if reviewing authority does not change, then you have a case. At this stage, you have no case.
Ballot, may I read the language for my satisfaction once? Now, Ballot, the rules says, similarly, while measuring the height fraction of centimeter less than such and such be ignored, and such more will be rounded off to the next higher centimeter.
Yes, that I have seen.
That was the duty of the person who was measuring at the first.
If it is wrongly done, then there is another tier to consider your grievance. Why you will not avail such remedy?
That, my lord, may I submit, lordship, kindly, my lord, gives me some time. Now, my lord, suppose my height was measured below 169.5, or say 169.4. I would have availed the appellate measure.
No, then you are disqualified. Even then you can avail of.
Yes.
But but when there is a measurement, suppose 169.7.
Yes.
It
So
is
I
much,
submit-
it
I
is better
automatically
case
qualify.
that it is to be ignored. 169.7, but you are declared not qualified.
Yes.
Then first authority where you should approach is the reviewing authority.
ওই আরেকটা যেটা হলুদ ফাইলে notifications গুলো আছে advertisement.
Where is the provision for review?
That portion I have not been, my lord, because, my lord, just one day ago, my lord, I have been engaged, my lord. My lord, I provide, my lord.
Bring that provision, not today. Not today.
Review provision is there, my lord. Review is there.
Bring that provision. Because in other matters, I have seen that in case of medical test, when the candidates are not being considered based on medical tests, reports, then all are approaching the reviewing authority.
Yes, yes.
And if thereafter it is found that the candidate is aggrieved by the review order, then they are approaching this court.
I review, my lord. The
Yes.
review is
So show me that the provision relating to review.
I will provide.
Yes, not today.
Much of it.
Not today, tomorrow you bring this review provision.
My lord, I have the review provisions with me. If your lordship wants today also, I can
If
say.
there is so, my lord,
Your lordship will, my lord, the
if
second,
available, my lord,
We'll come back at 2.
my lord.
Why you are not saying? I am when asking
My lord,
repeatedly.
last time I misplaced the file. So if I make a submission, I have to take the responsibility.
Continuing matter, item number 18.
No, my lord, what has fallen from your lordship, my lord, lordship will kindly permit me, and kindly doesn't take me amiss, that lordship, my lord, held probably that at the very threshold, the benefit of this rounding off will not be given, because there are two stages. What has been, my lord, shown by.
Where is the provision for review?
Matlab the provision 12.5.5. Matlab kindly go through one. 12.5.5.
This is not part of this document.
No, this is the advertisement.
Revised uniform guidelines for review. No, but it says revised uniform guidelines for review medical examination.
Yes.
In Central
that
Armed
is for
Forces.
medical. And if your lordship looks into the language, it says the medical board will not conduct this.
Twelve point 5.5.
12.5.5. The candidate.
Just a minute. What is PET race? There is no appeal in PET.
That is that running and other test that is conducted.
Physical eligibility
Yes.
test.
Efficiency test.
There is no review and appeal in that.
So why you did not prefer appeal?
My lord,
It says, it is very clear.
Yes.
That the candidates who are declared not qualified in physical standards, that is height and chest,
yes,
may not qualified, may prefer an appeal on the same day if they so desire to the appellate authority nominated for the center, though through the presiding officer. The decision of the appellate authority will be final and no further appeal or representation in this regard
yes,
will be
that is
entertained.
before the department, I won't be able to prefer any appeal and application. Now, my lord, if your lordship looks into the language, my lord.
So by this, by page 18, whether petitioner has been declared not qualified. Yes, not qualified.
Non-qualified. So, but my case is that.
Very well, I will direct the petitioner to prefer an appeal in terms of clause 12.5.5 by 7 days from date. And based on which the appellate authority shall pass an order, while passing an order, appellate authority shall consider the provision which the petitioner is relying upon. That is 2D.
Yes,
2D.
General instructions for recruitment of recruitment.
We have preferred an email on the subsequent date. That is, my lord, a part of the records.
We single petitioner.
No, my lord, two petitioners.
Or both are measured 169.5.
Between 169.5 to 169.
So this is one.
This is
169.9.
169.9. That's 160.5.
One is 169.5. And where is the another report?
Well, the phone page is 18.
Yes, yes.
Well, one is in page 18, your lordship will find that is 169.5.
Yes.
And another is in page 16.
16 double.
16, no,
No, 16.
Where is the report of another candidate?
What is that? 9.7.
No, single petitioner. You are making wrong submission.
Sorry, the next one was I was looking.
Yeah.
I was looking into that.
The single one.
বলবেন তো আমি তো একটা 10 সেপ্টেম্বর ভুল বলা হয়ে আকাশ ঘোষ
This is 169.5 centimeter.
Yes.
Yes. আসলে double petitioner ছিল।
It is in CRPF.
My lord, in page 19, my lord, there is a email sent on the subsequent date.
করে রেখে দিন।
Issue. Affidavit of service.
সার্ভিসটা দিয়ে দিন।
My lord, I'm handing over.
Affidavit of service filed on behalf of the petitioner is taken on record. Petitioner next paragraph. Petitioner participated in Constable GD. Now, petitioner participated for the post of Constable GD in Central Reserve Police Force within bracket CRPF. Within bracket for short CRPF. Close bracket. But in physical measurement, but in
CAPF.
CAPF.
Central Armed Police Force.
no, come to page 18. Not CAPF. First, against serial number 5, Constable GD in CRPF.
Yes, madam. Sorry. CAPF.
No, as such, my lord, the entire, my lord, was
কেউ বিপ পড়বে না এসো হ্যাঁ কি বলছিলাম but in measuring physical standards but while measuring physical standard, height of the petitioner was measured as 169.5 centimeter. Stop. It is submitted on behalf of the parties that minimum 170 centimeter is requisite height of a candidate in order to become eligible to be appointed as Constable GD. Next paragraph. Petitioner or on behalf of the petitioner clause 2 within bracket small d of uniform guidelines এখানে পাবে হ্যাঁ এই জায়গাটা uniform guidelines for medical examination test within bracket MET capital close bracket for recruitment in CAPFs comma NSG and NR is relied upon wherein it is provided that while measuring height fraction of centimeter less than 0.5 will be ignored and 0.5 centimeter and more will be rounded off to the next higher centimeter. Stop. It is submitted that placing reliance on clause 2D, aforesaid clause 2D, though petitioner's height was found 169.5 centimeter during physical measurement, but he should have been declared qualified. Next paragraph. Learned advocate representing Union of India submits that there is a provision for preferring appeal against the measurement made by the concerned respondent authority. Stop. In support of same, reliance is placed on a note on clause 12.5.5 12.5.5 5.5 of a notice published on the website on 5th September 2024, wherein it is provided that candidate who are declared not qualified in physical standards, that within bracket, that is chest and height and chest, close bracket, may prefer an appeal on the same day, comma, if they so desire, comma, to the appellate authority nominated for the center through the presiding officer, within bracket, capital P, capital O, PO, presiding officer. Stop. Next paragraph. It appears that petitioner is dissatisfied with physical measurement made by the concerned respondent authority on 20 August 2025 and subsequently filed the present writ petition questioning decision of the authority to declare the petitioner ineligible for being appointed as constable GD. Stop. Taking note of the relevant provisions relating to appeal, at this stage, court is not inclined to entertain this writ petition. Stop. Leave is granted to the petitioner to prefer appeal to the appellate authority questioning physical measurement made on 20 August 2025 by 7 days from date. Stop. If appeal is preferred within the aforesaid time, appellate authority is directed to decide the same in accordance with law. Stop. At the time of deciding the appeal, appellate authority shall consider clause 2D of Uniform Guidelines for Medical Examination Test, within bracket MET, close bracket, for recruitment of CAPFS, comma, NSG and NR and AR. Stop. Decision to be stop. Appeal shall be decided by fortnight from the date of preferring the same, and decision to be communicated to the petitioner by 10 days thereafter. Stop. Writ petition stands disposed of. Urgent Xerox certificate.
My grievance is that the routing of was not counted at the stage.
That I have recorded while recording your submission. Next matter. I have specifically recorded that 2D provides such. Next matter, please.
Item number 19. I'm responding.
Page 16, right, 169.7.
No. সেম ইস্যু ওটা 69.5 ছিল, এটা 69.7, ইটস বেটার কেস 69.7। হ্যাঁ সেম হবে, শুধু হাইটটা 169.7, সেম অর্ডার। ভেরি ওয়েল, 3 days। এই বাই 7 days যেটা ডিরেকশন আছে, ওটা অ্যাপিল টু বি প্রেফার্ড বাই 3 days from date।
Fortnight from that date.
Yes, fortnight, 10 days।
Not
Item number 20.
20, your lordship, appear for the petitioner.
Item number 20, for the Union of India, my lord.
Lordship, I'm appearing for Shama Prasad Mukherjee Port Trust. Just one indulgence, Your Lordship. We have not
Happy
yet
to
received
hear,
the
sir.
copy of the writ petition.
Not today.
Lordship,
Lordship.
in that event, your lordship, kindly makes it, your lordship, day after tomorrow, your lordship.
Lordship,
Lordship, may I only indicate this much, your lordship? We have served, your lordship, upon all the respondents, your lordship. Only, your lordship, it is the,
When you have served, 1st of
Lordship.
November filing.
I have served on that very date only. It was served on 3rd of November. It was,
They will come back on Wednesday.
Lordship,
lordship.
may I request, it'll take me much more time to get some instructions. I don't even have the copy.
Lordship, and then in that event, your lordship, what are we asking for, your lordship? They are working as, lordship, only I'll take only 1 minute of your lordship. They are working as the contractual dock pilots. And now they have come up with a fresh advertisement for appointment of the apprentice dock pilots. Lordship, we
When
are
advertisement was made?
Lordship, now this advertisement is dated. I'm only
21st September.
24th September 2025. Now this advertisement, your lordship, they say, your lordship, these vacancies are coming from 2012-14 and it is continuing. Lordship, we are engaged as the contractual dock pilots in the year 2012 and 2014. We have completed 10 years of service. We made our representation for regularization. Your lordship, herein, we are praying that we as dock pilots, we are issued the same license which are issued to the regular dock pilots. We were never considered, despite our representation, your lordship, on the concept of regularization.
Come back Wednesday, otherwise I have to
Lordship.
protect the
Lordship, I
petition.
will come back.
Lordship, grateful, my.
May I request them to serve a copy?
Lordship, today itself.
Yes.
Item number 21.
My lord, I am appearing on behalf of the petitioner, my lord.
Who is appearing for the other side?
My lord, I have served the copy to the government, my lord.
Lordship, received the brief on last Friday, my lord. So, my lord, I have to take instruction. I have already sought for instruction Friday evening, my lord.
Come back. Tomorrow?
No, my lord. Not
Then Thursday.
Okay. Top of the list, my lord. My lord, top of the.
It will retain its position in the supplementary list. Thursday. Huh? Yes.
Item number 48 from monthly list.
I appear for the petition.
Who is for the other side?
My lord, Mr. Dheeraj Tribuji, he was appearing.
Where is he?
My lord, he did not come today.
Not today. There is a resolution.
Just one thing, just to point.
Please come, not today.
No, I'm not married. When I was arguing before this court, another court, then question of on the ground of maintenance.
Well, I will hear you on the next day. Yes.
Item number 68.
68. Right.
All parties are present. Not today.
Item number 69.
69. No, there was a direction for the.
On the last occasion, there was a direction to file report by respondent number 4 and 6. We have not yet received. We have not yet received any.
Government of India. Government.
4 and 6.
4 and 6.
4 and
Kindly
kindly peruse the order.
ভুলভাল হয়েছে কি দেখি দাও 4 and 6 কে কে আছে FCI দেবার কিছু নেই 4 and 6.
That is the order, last order.
Well, 6, well, we have nothing to in this matter. We have said that.
But there was a direction. What can be done?
Direction, well,
He's present.
If you do not want to file an report, then I will record it.
Well, question is this: well, last occasion the direction was upon the government of India.
No,
maybe
4
well,
and
there is
6.
maybe
4 and 6.
Both.
4 and 6.
Who is appearing for the state? Government of India.
Government of India has to give.
Who is appearing for the Union of India?
Union of India. I don't know who is appearing. In this matter, the question of jurisdictional politics.
Will come back today. There is a resolution, not today. Union of India is not represented. But if there is a direction, you have to file a report. Otherwise, court will record that you do not wish to file it.
Then I have to take time.
No issue.
I thought about the number, maybe there is a mistake.
Then kindly keep it on next Monday.
Let it retain its position. Let Union of India comes.
Item number 71.
I appear for the respondent. My lord.
I beg to appear on
May
behalf of
obtain
the
a petition.
Yes, where is the notification?
My lord, I rely upon some judgment of the Honorable Supreme Court, my lord.
Item number 201. Serial number.
So this is a notification under section 14 subsection 2. Do you have the full notification, entire notification? This is the entry from 192.
My lord, what generally happens is that after like this is the notification dated 31st of March 2010 by which
I want the full notification.
I will try and get it, my lord. This is the notification that I've been provided. I'll try and get it. This is what we rely upon when, my lord, generally. My lord, this. Not according to me, what I understand, this is the entry.
Wait. This is a notification under section 14.2 and 14.3.
Lord, may I just take your lordship to section 14, my lord? Subsection 3 is where the additional power has been given to add other corporation of the central government if they wish to, if the central government wish to bring it under the purview of the Central Administrative Tribunal.
Do you have the copy of Administrative Tribunal Act 1985?
The act I have, my lord.
Come to section 14 subsection 3.
My lord, prior to coming to the section, my lord, I would like to place before your lordship.
Please come to section 14 subsection 3. Judgment will come later. Please come to section 14 subsection 3.
My lord. Save as otherwise especially provided in this act, the Central Administrative Tribunal shall also exercise it the addition of parties.
Shall also exercise.
Also exercise. On and from the date with effect from which the provision of this subsection apply to any local or other authority or corporation or society. All the jurisdiction, power and authority exercisable immediately before that day by all the courts except the Supreme Court in relation to subclause A and B. Recruitment, matter concerning the recruitment to any service or post in connection with the affair of such local or other authority or corporation. That is not my case. I have been recruited in 2013. Man.
All service matters. What is your prayer in the writ petition?
My lord, the case of the petitioner is that the petitioner was appointed in 2013, my lord. The first promotion, there is a policy of collector.
It's a promotion matter.
I am coming.
Please, it is a promotion matter.
Issue related to
so
promotion.
It is not a service matter.
My lord,
it says all service matters concerning a person other than persons referred to in clause A or clause B of subsection 1 appointed to any service or post in connection with the affairs of such local or other authority or corporation or society and pertaining to the service of such person in connection with such affairs.
Please prove me,
Now,
my lord.
now it says subsection 3 is significant.
My lord.
It says as otherwise expressly provided in this act, the Central Administrative Tribunal shall also exercise on and from the date with effect from which the provisions of this subsection apply to any local or other authorities or corporation or society, all the jurisdiction, powers and authorities exercisable immediately before that day by all courts except Supreme Court.
My lord.
So including high courts.
My lord, I understood.
So where is the jurisdiction?
My lord.
This court cannot take up this matter. There is a statutory bar.
It is not absolute bar, my lord. That is the Supreme Court held, my lord. I am relying upon some judgment of the Honorable Supreme Court. The one judgment is by the Honorable Justice HON'BLE. The first judgment is Godrej Sar Ali Limited versus Exercise and Taxation Officer. The judgment is passed by the Honorable Justice Ravindra Bhatt and Dipankar Dutta, my lord. 2023 SSC Online SC 95.
Which paragraph you are referring?
I am relying upon the paragraph number 4 to 8, my lord. I read for your lord convenience. Before answering the question, we feel
just a minute.
No problem. Very good. তোমার জন্য একটা জিজ্ঞেস করে নিলে ভালো।
It is a case of alternative remedy.
My lord.
And this court is considering the fact where it, in view of L. Chandrakumar's judgment,
My lord.
it is the only remedy. You have the only remedy to approach the tribunal. If you fail in tribunal, then you can file a writ petition before the division bench of this court.
Under Article 226, my lord, my lord can.
It is not a case of alternative. Suppose you are
lord.
challenging the order of a disciplinary authority.
My lord.
There is an appeal provision.
My lord.
Now, without exercising the appeal provision, you come straightway. There are curtain of judgments where the Supreme Court has held that if there is glaring violation of principle of natural justice, then alternative remedy is no bar. High Court can entertain, but it is not a case of the case at my hand. Your case is not a case of alternative remedy. It is a case of only remedy.
Section 28 of the Act itself is also a bar. My lord, may I rely upon this judgment? This is on this point.
My case, my lord, kindly
This is on the
let me place my
jurisdiction
case,
of CAT.
my lord, what will be done, I
Considering
will
L.
follow by
Chandrakumar as the captain of judgments.
My lord,
These are two.
the case
Let
of
him finish.
the case of the petitioner date, my lord. The petitioner was appointed in 2013, my lord. there is a policy of cluster promotion, my lord. The entire batch is being promoted, is given promotion, my lord. In 2017, my lord, the petitioner was promoted from S3 to S4. In 2021, my lord, the petitioner along with the entire cluster, my lord, was promoted from S4 to S5, my lord. In 2024, my lord, except petitioner, entire batch is given promotion, my lord. Petitioner made a representation, my lord, but there is no answer, my lord.
Yes, please,
Now, my lord,
It's
during
not required.
my lord,
Supreme Court, my lord,
my
what
lord,
this point?
during the pendency of the report, my lord, they have admitted that I am eligible. This is a promotional certificate, my lord. Can we look at this, my lord? There remain nothing, my lord. Only the date of effect should be corrected, my lord.
On hearing the learned advocates representing the parties, it appears
And see, my
that petitioner
has been solved, my lord.
is an employee
No fruitful purpose is served by sending
of
before the tribunal, my lord. That's my humble prayer, my lord. They
Steel
have admitted
Authority
the
of
fact.
India Limited within bracket SAIL, and issue involved in this writ petition pertains to promotion.
The promotion has been granted. Kindly look at the promotional certificate issued by the authority, my lord.
Pertains to service of the petitioner being employee of SAIL. Within bracket for short SAIL করে দেবো. Stop. Next paragraph, at the threshold, learned advocate, you are representing SAIL.
I'm Steel Authority of India. Yeah, I love all the rest. Steel Authority.
Union of India.
I'm
My lord, Union of there was a
Union of India will represent.
At the threshold, learned advocate representing SAIL has questioned the jurisdiction of this court to entertain this writ petition. And এদিকটা রাখো না, লাগবে আমার এফিডেভিট সার্ভিস দিচ্ছে। And
promotion has been granted, my lord.
reliance is placed on section 14 and 28 of the Administrative Tribunal Act, 1985. It is also submitted that in terms of in view of notification dated 31st March 2010, now it is also submitted that notification dated 31st March 2010 was issued in terms of section 14 within bracket 2 and section 14 within bracket 3 of the Administrative Tribunal Act 1985.
Promotion has been granted. That is the
Wherein certain entries were made after serial number 191. In the schedule of the said notification.
2010-এর নোটিফিকেশন তারপরে
thereby declaring
আমি পাইনি। This matter, my lord, I have to come that there is a subsequent amendment in the notification, my lord.
15th April 2010 as the date on and from which provisions of section 14 within bracket 3 of the said Act of 1985 shall apply to sell. উপরে না said Act of 1985 করবে। In the schedule, sale is specified against serial number 201. Next slide. Learned advocate representing the petitioner
No, there are some changes in
has relied upon judgment of the Honorable Supreme Court reported in 2023 SCC Online SC 95 within bracket Godrej Sara Lee Limited versus Excise and Taxation Officer cum Assessing Authority and others in order to demonstrate before this court that alternative remedy is no bar in entertaining the writ petition.
The second judgment of 2008, my lord, para number 3. The Supreme Court in 2008 also held the same principle. My lord. If my lord come to
It is observed in paragraph 4 of Godrej Sara Lee Supra, Godrej Sara Lee Supra, that it is axiomatic that the high courts within bracket bearing in mind facts of each particular case, close bracket, have a discretion whether to entertain the writ petition or not. It is submitted that on such issue there are other judgments of the Honorable Supreme Court. That alternative remedy is no bar in entertaining the writ petition. Next paragraph.
come to the
Taking note of the submissions made on behalf of the parties and the law enunciated by the Honorable Supreme Court in Godrej Sara Lee Limited, Supra, or Godrej Sara Lee Supra. It is apt to observe that it is right that availability of alternative remedy is no bar in entertaining the writ petition, in entertaining a writ petition in a particular case. But the case at my hand is not touching upon identical issue. Rather, this court is required to decide the issue based on section 14 of the said Act of 1985. Which operates as bar in entertaining a writ petition pertaining to service of an employee working in cell in view of notification dated 31st March 2010.
It is an admitted position, my lord.
Stop. It is not a case of alternative, it is not a case of availability of alternative remedy. Rather,
My lord, kindly come to the
it is a case of
judgment 2008, my lord.
only statutory remedy available to the petitioner at this stage of the proceeding to approach Central Administrative Tribunal.
Kindly come to the judgment of 2008, my lord,
Next
para
paragraph.
number 5 only.
In view of aforesaid, no relief can be granted to the petitioner. Writ petition stands dismissed. However, this order shall not preclude the petitioner to approach Central Administrative Tribunal in accordance with law in pursuit of his grievance.
But my lord,
In pursuit of redressal of his grievance. Stop. Urgent Xerox certificate.
promotion has been granted, my lord. Only the date of effect is need to be corrected only, my lord. There remain nothing, my lord.
Next.
Obligation.
Try to understand the predicament of this court.
My lord, the promotion, they have
Don't,
admitted that
you are an advocate of this court, don't invite this court to pass a wrong order.
my lord,
Please call the next matter.
Item number 73.
Yes, yes.
I appear for the statement.
Who is for the petitioner? Not today.
74.
My lord, Advocate Kakoli Samajpati is appearing this matter for the LICI.
Not today.
Not this, I'm praying for not this week, my lord.
No, petitioner is not there. You are whether Kakoli Samantar is appearing for petitioner?
LICI, my lord.
No, sorry, not today.
75.
The petitioner, my lord, I'm praying for not today.
Not today.
I appear for the respondent.
Oh, that matter, Dhanbad.
No. That is
No,
the
no.
next matter.
Yes.
Item number 79.
This is that matter.
All parties are present. Union of India.
You will not meet as party yourself. To earlier occasions, Lordship, I have raised the point of territorial jurisdiction on the ground of that, Lordship. Writ petition cannot be maintainable before this honorable court, Lordship. On this court, Lordship, there is a judgment of Honorable Appellate Lordship. I will hand over, Lordship, and as well as the Honorable Lordship coordinate bench of this honorable court, Lordship, recent judgment. Now, Lordship, kindly see. Page 1, Lordship, the cost title. First are the petitioners, Lordship. Kalyan Kumar Mukherjee, Lordship, Dhanbad, Jharkhand. Then Lordship will see page 2, respond number 3, 5, 7, and 8. And admittedly, Lordship,
Petitioner was an employee of Bharat Coking Coal.
Bharat Coking Coal Limited, Lordship. That is why, Lordship, I am referring, Lordship, respond number 3, 5, 7, and 8, Lordship. Now, Lordship, kindly come to paragraph number 1, Lordship, page 3. Second line, Lordship, in the bottom portion. The petitioner has been serving under BCCL, a subsidiary of Coal India Limited. Now, Lordship, thereafter, Lordship, will come to paragraph 3. By virtue of his appointment as surveyor under BCCL has been performing his duties diligently for 2 decades. Now, Lordship, we come to
No, where is the order of
Lordship.
It's an stoppage of increment. Yes.
Lordship,
Where is that order of stoppage of increment? Page 18. Just a minute.
Kindly see, before that, kindly see page 17. The chart sheet was issued from the BCCL situated at Dhanbad.
Yes.
And
where is the jurisdiction of this court?
And
you are an employee of no further dilation is required. You are an employee of BCCL.
Kindly check my prayer. My prayer is regarding promotion. Under this the subsidiaries of Coal India, promotions are taken control by the Coal India Limited. The notification promotions are issued by Coal India. Promotion orders are issued by Coal India. because after promotion, my lord, it's interchangeable. A particular employee from BCCL, if promoted, my lord, from non-executive to executive cadre, he might be posted in some other subsidiary under the BCCL. Kindly comes to the notification of promotion, my lord, at page 23.
And Lordship, I have not completed, Lordship.
No, no, I'll hear you.
Lordship.
This is the notification at page 23.
So there is no role to play by BCCL.
No, in promotion, no role. The fact is, I have not challenged the penalty order. Had I challenged if my cause of action, the petition was relating to the disciplinary proceeding, the penalty order, then the answer respondent would have been BCCL. Here, my prayer, kindly check my prayer, my lord. I am praying for promotion.
Let me hear Coal India Limited. Coal India Limited. He is representing BCCL. Serve notice upon the learned advocate who represents Coal India.
And Lordship, prior to that, the kind
You are not representing Coal India.
আপনি কি কোল ইন্ডিয়া অ্যাপিয়ার করছেন, মাইনর জিজ্ঞেস করছেন?
Are you representing Coal India?
No. We are not representing Coal India, Lordship, as per my instructions.
May I file my service, my lord? I shall serve another. I shall effect another service upon Coal India.
No. Have you served upon Coal India? File.
Kindly page 33.
Affidavit of service filed on behalf of the petitioner is taken on record. Having considered the point of jurisdiction taken on behalf of
BCCL, Lordship.
Bharat Coking Coal Limited within bracket BCCL. Court finds it is necessary to hear Coal India Limited being respondent numbers 1, 2, 4, 6, 4 and 6. Stop. Learned advocate representing the petitioner. কি বললাম last sentence টা? Now, court desires to hear Coal India Limited being respondent number so and so. Next paragraph, learned advocate. Next paragraph, in spite of service of notice, Coal India Limited is not represented. Stop. Learned advocate for the petitioner is directed to serve notice upon Coal India Limited or upon non-appearing respondents or the learned advocates representing those respondents, enclosing copy of this order by November 2025 and file further affidavit of service on the next date. List the matter under the same heading for further consideration. List the matter under the same heading for further consideration on 24th November 2025. Let Coal India come and say that this promotion is fully controlled by Coal India.
Great.
Yes, next matter.
Item number 80. I am for the petition led by Mr. Shokojay. In this matter, my lord. Previous petitioner is a lady, my lord, who is serving as a laboratory technician under the Howrah Gazipur PBCs.
My lord, there is a age-related issue, my lord. As per his admit card, 1965, 19 January 1965, as per his admit card, my lord. Subsequently, my lord, the affidavit and other documents, my lord, his actual date of birth is 6 May 1917. My lord, the renew, lordship kindly come page 25 is a non-renewal. Page 28 is a representation.
Yes, you are praying for changing date of birth.
My renewal has been my non-renewal is page lordship.
Renewal?
Non-renewal of contract, my lord. This page 15 January 2025 is page 25, lordship.
Page 25.
25. This is the, my lord, order which was issued by the chief medical officer of the health, member of the secretary. My lord, my date of birth is here mentioned, my lord.
Just a minute. What is NTEP?
NTEP, lordship, is the
Non-technical or
NTP.
What is NTEP?
Non-tuberculosis unit, lordship. Microscopic under the non-tuberculosis unit.
Yes, date of birth 19 January 1965.
My actual date of birth is 6 May 1970. The page 26 is the
6th May.
6 May 1970.
Why at the time of first contract you did not bring it to the notice of the authority?
We
Why at the time of issuing, at the time of refusing to renew your contract, you are raising this issue?
Lordship, that is the fact, lordship.
Yes, it goes to show that you are trying to work even after the age of 60 years. If my date of birth is incorrectly considered by the authority at the time of my engagement, on the first date it will be raised, the objection will be raised, would be raised by me.
But we have submitted all the, my appointment is 2013, lordship.
Yes, so from 2013 you are working, and when your contract was not renewed, now you are taking this point.
Lordship, prior to the, my lord, we have made a representation is page 27, my lord.
No, it's not a case of representation. Answer the query of this court. Why, from which date you are working as?
Lord, at the time of, my lord, appointment letter, my lord, we have made the necessary verification. We have submitted, my lord, everything.
Show me that you have submitted everything.
Well, that documents is not, my lord, my client has no documents, my lord. Only, my lord,
First thing,
page 28 is the representation.
Page 25, when the notice has been served, he is informing her date of retirement. That is on 15th January 2025. And see the next page, my lord, you see, immediately thereafter, yes, affirm an affidavit. What is the date? 27th January 2025.
From which date petitioner is working as employee under?
Come to the annexes.
Where is the engagement letter? Where is the engagement letter?
Engagement letter is, lordship, page 19.
Melody. Page 3 of my that report I have filed.
Both of Microsoft contractual basis.
Page 2 of the report, the joining letter.
National Board of Secondary Education. 65. Not the number. 65. Another. All educational grade. Similar to 65. So I can change it.
So he was appointed on 8 June 2013, engaged as under BPA in BPHC Block Primary Health Center.
Gazipur.
Yes,
Gazipur, Lordship.
Gazipur.
Gazipur.
Now, at that point of time, what are the documents which were placed before the authority for consideration of his data of her date of birth?
Yes, Annex, page 16 and 17.
Honorable Board of Secondary Education.
Degree petition.
Yes, 19 January 1960, 19th day of January 65, 1965.
Lordship, the other document.
Say admit card.
The Lordship, the other documents is date of birth is.
And now you are relying upon this affidavit.
Affidavit, Lordship, affidavit and the representation, Lordship.
The next page, my lord, this
So against this admit card, you are relying upon this affidavit.
and the yes,
Lordship, rest of the documents.
certificate also. Past certificate is also there.
Issue.
Then PAN card.
Affidavit, file your affidavit service.
Lordship.
Affidavit of service filed on behalf of the petitioner is affidavit of service filed on behalf of the petitioner is taken on record. Stop. Petitioner prays for change of date of birth, which would permit her to get renewal of service contract for a further period. Or for an extended period. Stop. Petitioner was initially engaged on contractual basis in Gazipur Primary Health Center, Howrah, and at the time of initial engagement in 2013, in May 2013, in support of her age proof, petitioner submitted admit card in connection with petitioner's participation in Madhyamik examination and certificate of Madhyamik Pariksha within bracket secondary examination. So both the aforesaid documents, that is admit card and certificate of secondary examination, corroborate date of birth of the petitioner is 19 January 1965. Next paragraph. However, after receiving memo dated 15 January 2025 issued by the Chief Medical Officer of Health and Member Secretary, DH and FWS, Howrah, whereby prayer of the petitioner for renewal of service contract was denied. Stop. In the said order dated 15 January 2025, concerned state authority decided not to renew service contract of the petitioner, taking note of the fact that petitioner would attain 60 years of age on 19 January 2025. Considering date of birth of the petitioner, January 1965. Stop. Next paragraph. Petitioner on receipt of order dated 15 January 2025 affirmed an affidavit on 27 January 2025 and stated that date of birth of the petitioner is 6th May 1970, not 19 January 1965. Prayer is made for passing necessary order by the concerned state authority renewing service contract which would permit the petitioner to work for a further period of 5 years. Stop. Next paragraph. Prayer of the petitioner is opposed by the learned advocate representing the state respondent on the strength of admit card and certificate of Madhyamik examination containing date of indicating date of birth of the petitioner is 19 January 1965. Next paragraph. Having considered the submissions made on behalf of the parties, it appears that petitioner was initially engaged on contractual basis with effect from with effect from May 2013. And it was the petitioner who submitted admit card and certificate of secondary examination. Stop. Based on these documents, concerned respondent authorities decided. Concerned respondent authority maintained a record of service of the petitioner wherein it was maintained record of service of the petitioner stating date of birth of petitioner is 19 January 1965. On periodical renewal of service contract, petitioner worked from May 2013 to January to January 2025 to January 2025 without raising any demur relating to date of birth of the petitioner, or without raising any demur relating to her date of birth. Stop. After issuance of order dated 15 January 2025 deciding date of retirement of the petitioner is 31st January 2025, as petitioner would reach age of 60 years on 19 January 2025. Petitioner affirmed an affidavit on 27 January 2025 declaring her date of birth is not 19 January 65 but 6th May 1970, which appears to be afterthought. Stop. Had it been a bona fide case of wrong recording of date of birth in the service record of the petitioners, she could approach the concerned state authority for correction of date of birth after being engaged on contractual basis initially, just after being engaged on contractual basis initially in the month of May 2013. Stop.
One document, my lord.
Stop.
His PAN card.
Next paragraph. In this regard, reliance is placed on the judgment of the Honorable Supreme Court, reported in 1994, supplementary within bracket 1, SCC 155, Home Department versus R. Kirubakaran. And another judgment reported in 2011, 9 SCC 664 within bracket State of MP versus Premlal Srivas. এটাই পাবে, হ্যাঁ, এই প্যাজিনেশন নেই, প্যারাগ্রাফ 9 Premlal Srivas. Stop. Next paragraph. Having considered the efforts in aforesaid conspectus, no relief can be granted to the petitioner Writ petition stands dismissed. Urgent xerox subject. এটা এর মধ্যে দিয়ে দিন বলে আমার ফেরত দিন।
Item number 81.
Not today.
82.
Not today.
83.
Not today.
84.
84, we have prepared an application, my lord, in respect.
Yes, yes, 84. Three minutes left.
I know, my lord, but I can, my lord, only tell your lordship this. My lord, there was an interim order passed in this matter. My lord, it was carried in appeal. My lord, in the appeal, it was agreed that on the, we'd asked for a modification. My lord, that is, my lord, recorded, my lord, in the order. It's in can 4. My lord, your lordship will find that. My lord, the interim order, my lord, is at page. Oh, sorry, can 1, my lord, page 28. 18th August 2025.
So in in application, what you are praying for?
Yes, my lord, what happened was, my lord, this is a challenge to, my lord, the 2016
rules.
16 rules, my lord. My lord, earlier was 2009. This is, my lord, 2016. My lord, it pertains to development officers of, my lord, LIC.
Show cause notice issued.
Yes, my lord, show cause notice issued. Ground of challenge is, my lord, challenging the vires of the 2016 rules. Now, my lord, some interim orders had been passed.
But there is an SLP pending before the Supreme
My
Court.
lord, that's wholly immaterial. My lord, that's what I wanted to say. My lord, Allahabad High Court had also not decided this issue finally. Now, my lord, is decided the issue finally. So, my lord, either an SLP is pending, there's no stay. Now, my lord, the point.
25th November SLP is fixed.
Nothing. Every day it's been fixed, it's not being taken up. Now, my lord, the important thing is, my lord, we pointed out, my lord, to the bench, my lord, who had, my lord, taken up the appeal, that in Kusum Ingots, my lord, the court has said, my lord, one high court order, my lord, on the vires, my lord, will be binding pan-India. Because now what is happening, Bengal, my lord, is the only state where, my lord, courts have said, because SLP is pending, in spite of Allahabad High Court order, you keep on not passing final orders. So, my lord, today, my lord, LIC, my lord, who's in the insurance business, my lord, there are
happening for LIC.
So, my lord, last time, my lord, I think Mr. Kollol Bose had appeared.
Today there is a difficulty.
No, I know that. My lord, so, my lord, kindly, my lord, let it remain in the list, my lord, I'll inform. Yes, my lord, Mr. Kollol Bose, my lord, I'll find him. My lord, it's the only state where, my lord, they are continuing just by coming, filing, challenging vires.
So let it remain in the list,
Yes.
or I'll very well let it remain.
Yeah,
in the
yes,
combined matters. I do generally do not bring it.
No, kindly don't, my lord. Let it remain where it is, my lord. Otherwise, again, they'll be said there was a etc., my lord. So, because, my lord, close to, my lord, 9 crores, my lord, Bengal, my lord, is paying development officers without, my lord, an adjudication on show cause, when, my lord, the Supreme Court has said that, my lord, if they do not, my lord, deal with, my lord, their duties efficiently, it's, my lord, without stigma, but, my lord, their services are terminated.
Now, Mr. Mukherjee, you are praying for getting the benefit of Allahabad High Court.
Correct. My lord, that's operating now. LIC is applying it in every state. Every high court is agreeing to it. Oh, my lord, don't touch the matter at all.
Protected in the meantime.
No, where? I have to pay their salary. My lord, my termination, my lord, I can't even proceed with that. They said go up to a point, but don't pass an order. And, my lord, these are persons who have to procure business. They are field agents. My lord, now insurance sector has opened up. My lord, we are competing. It's no longer a monopoly.
Let me hear the.
Yes, of course. আচ্ছা